ಏನು ಅರ್ಜೆನ್ಸಿ? ಇನ್ನೊಂದು ಯಾವುದು? ಪ್ರಿಮೇಚೂರ್ ಟ್ರಾನ್ಸ್ಫರ್. ಸರಿ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕ್ಬೇಡಿ. ಹೌದು ಹೌದು, ಅದು ಮೆನ್ಷನ್ ಮಾಡಿದ್ರಲ್ಲ, ಯಾಕೆ ಬಂದಿಲ್ಲ ಅದು? ಟುಮಾರೋ. Why is not audible? Yes. ಏನು ಅರ್ಜೆನ್ಸಿ?
ಅರ್ಜೆನ್ಸಿ ಅಂದ್ರೆ ಸೆಲೆಕ್ಷನ್ ಲಿಸ್ಟ್
selection matter. Next.
My lord, matter pertains to Panchayat government officers, my lord. My lord, there was an order of this honorable court to consider their cases for the seniority list. Lord, in spite of
Next week,
my lord.
Kindly, my lord, this matter, my lord, now. That day I take password on Monday, my lord. That, my lord, where petitioner is a lawyer, where the termination of wakalat is challenged, my lord. Maybe tomorrow, my lord. Day after tomorrow, matter is listed before the learned single judge. Only in 6 matters, my lord, which are listed.
learned single judge are terminated.
Yes.
On what ground?
It's, my lord, saying that, my lord, it's a successive petition. These petitions are not successive, and this particular lawyer is disabled before the learned single judge. That is the contention, my lord. That, my lord, some stigmatic allegations.
Monday.
Kindly, matter is before.
Yavatide.
Friday is before
My
the.
lord, it's to a matter relating to seniority, my lord, of Panchayat development officers. Matter is pending since long, and this is a matter relating to seniority of around 3,000 Panchayat development officers.
Sorry, Monday.
Lot of matter
Tuesday.
My lord, it has not been listed therefore.
Monday. Memo ಬಂದ್ಮೇಲೆ ಎಲ್ಲ ಬರಲೇಬೇಕಂತ ಹೇಳ್ಬೇಕು ನೀವು ಆಫೀಸ್ನವರಿಗೆ. ಇಲ್ಲಪ್ಪ ಅಂದ್ರೆ ಪಾಪ ಅವರಿಗೆ
My humble submission before this honorable court on 18/3/2025, the judgment passed by this honorable court.
ಏನ್ ಮಾಡ್ಬೇಕು ನಾವು ಈಗ?
Being spoken to memo for post.
Being spoken to you file ಇರೋದಿಲ್ಲ ಇಲ್ಲಿ. ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ನಾವು ಸೈನ್ ಮಾಡಿಬಿಡ್ತೀವಿ ಸೇಮ್ ಡೇ. ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ. ನಾಟ್ ಓಕೆ
Please, sir. Much.
ಅಲ್ಲ, ವಿಜಯ್ ಕುಮಾರ್ದ ನಾಳೆ ಇದು ಕೊಟ್ಟಿದ್ದೇವಲ್ಲ, ನಾಳೆ ಹಾಕಿ ಎಲ್ಲ ಒಂದು ನಾಳೆ ಒಂದು ಇದು ಸಸ್ಪೆನ್ಷನ್ ಏನೈತಿ ನಾಳೆ ಹಾಕ್ಬೇಡಿ. ಎಸ್,
item 24, my lords.
It
was the CCS filed an application, my lords, for seeking that the appeal is not maintainable because of monetary limit. We have sought instructions from the department, my lords. Because of the end of financial year, all the offices occupied.
My lords, may I say something?
2 weeks, my lords.
2 weeks.
I want to say something, my lord.
The reason.
Yes.
May I say
23
something?
matter.
23 matter, my lords. Because the instruction that they've given, my lords, is not very complete today.
What is there? Whether it is in limits or not,
Yes,
that
my
is
lords.
the only
My lords,
question.
the issue is, my lords, is much more detailed, my lords, which is not very clear from the instructions. So I've reached out to again, my lords, please give me these instructions.
Tuesday money.
My lords, may I say
Tuesday,
something?
Wednesday, my lords.
I want to say something.
Wednesday, my lords.
I want to say
Yes,
something.
yes.
Can kindly have it on turn, because I want to
Yes.
show how they have been trying to avoid this case. In August 2024, this court directed me to file on the same day, working one sheet working on how it is below lower monetary limit. After 6 months, it comes up. Last time, my friend says I have received instruction. Today, I am filing the reply. And again, today he comes and takes adjournment. Adjournment at the end of the day is the honorable court's exclusive privilege. But I am being made to appear every time.
Avoiding the court.
No, my lords. My lords, if the matter is not maintainable, the matter will go, my lords. We have no problem with that.
We'll post it before the other bench. But don't
No, my
go
lords,
on
not
taking.
avoid.
We'll say let it be posted before other bench.
No, my lords. That's not the intention at all, my lords. The reason is, my lords, they have given us a number, but they've not given us the breakup of that number, my lords. May I request
I will give everything.
6
months agide.
Yes, my lords. My lords, they've given me an instruction, my lords, but number is not been split up.
I will give the working.
Irrespective of
you give that breakup now only.
They have given me the breakup, my lords. I've sought for income tax department to give me a breakup as to why they say is maintainable. That is the reason. Wednesday, my lords.
Wednesday.
I'll finish it off Wednesday, my lords.
Call this matter Wednesday finally.
Final notes.
At the request of learned counsel, panel counsel appearing for the revenue. If you want that matter to be posted before other bench,
My lord.
right now we'll say that.
No, my lord, I don't want it, my lord. I'm not making a request.
Wednesday, don't.
Wednesday,
be-
my lord. Wednesday,
Obli-
Obliged,
any time.
obliged to my lords, obliged to my lords.
Trouble assesses unnecessary.
Yes, my lord.
Yes.
For order still number one, government advocate.
Lords, I
Ah.
speak about 2 weeks' time, Lords, for compliance.
12 office objections,
My Lords, unfortunately.
2 weeks. Finally, filling which petition stands rejected.
My Lords,
Still number two, Sushal Tiwari.
My lord, inadvertently some pages have been missed out, my lords. I'll file the pages, my lords. 1
10
week, my
days
lords.
for compliance. Filling which appeal stands rejected.
Yes, my lords.
Still number three, yes, Anmati.
My lord, this matter, my lords.
Third
might be
time,
Conflicted, my lord. Maybe, my lords, this bench is disabled, my lords.
disabled.
Yes, 3 and 11, my lords.
3 and 11 before other bench.
Number four, Arvind V. Chauhan.
Serial number 4,
Ha.
the first matter, my lord,
Notice.
Huh?
I accept notice on this.
Maintainability of value of tax effect.
my lord,
Value
regarding
of-
first matter,
Huh.
there is a connected matter where the penalty order has also been challenged. It is ITA number 237. Both may be tagged along, my lord. Next week it may be taken up. I'll make my submission.
Call along with maintainability,
237, ITA 237 of 24.
below 2 crores.
This is below 2 crores.
Huh.
Penalty is above 2 crores. So both may be clubbed next week. It may be taken up.
All right. Call these matters along with ಬೇರೆ ಯಾವ್ದು ಇನ್ನೊಂದು
ITA 237.
237.
My lord, second matter, it is below,
ನೋಡಮ್ಮ.
it may be.
I accept notice in serial number 4, my lord.
4 you appear.
Yes, my lord. I accept notice, my.
Annamalai. Yes, Annamalai.
4.1, it is below monetary limit
ನೋಡಮ್ಮ.
with that liberty.
ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಆರ್ಡರ್ ಇದೆ ಗೊತ್ತಾ?
Standard order, please.
There is a standard order below limit ಇರೋದಕ್ಕೆ ಕೇಳ್ಕೊಂಡು ಮಾಡಿ.
Please.
Circular number. Circular number. Circular.
ಸರ್ಕ್ಯುಲರ್ ನಂಬರ್ ಹೇಳಿ.
Circular number
9 of it.
9 of,
Registry to send a copy of this order to the respondent assessee. Okay. By speed post immediately. Yes.
Still number five, Reshma Kitty.
Yes. Reshma, madam.
My lords, if I may submit, my lords. Lords, my suspension was based on the impugned order at page 41, my lords. My lords, if my lords
On
may
the
take.
last occasion, there was a direction, man.
Correct.
Sorry to interrupt, my lord.
All right. Where is that video?
Pen drive is
Drive is
available, my lord, and even the timestamps at which point in the video is there is audio recording of his demanding bribe is also mentioned.
There.
There is a clear recording.
At 2:30. We look into it and come back. 2:30. ಇದನ್ನ ಇಸ್ಕೊಳ್ಳಿ. Pen drive ಇಸ್ಕೊಂಡು ಒಂದ್ಸರಿ ತೋರಿಸಿ. Both of you come to chamber at 2:35.
Please,
Please, my-
Or at 1:20.
please, my lords,
At 1:20.
please, oblige.
No video. Yes.
Still number six, K. Sridhar.
Yes,
Appear for-
Mr. Sridhar.
Matter, my lord, on the last occasion, I had sought time, my lord, from your lordships to verify whether the repatriation of the resultant vacancy from the repatriation of the
How
staff
you are-
nurse to HF has been filled up, my lord. It has been filled up, my lord, and with by a qualified,
Mr. Sridhar said there are only 5 persons working out of
my lord, the officers are present. my lord.
21
On
post, my lord.
instructions, I am submitting that those posts have been filled up, and in fact, my lord, the HF, the Department of Health and Family Welfare is not a party. But I also verified from the department secretary itself that there is dearth of staff nurse in the HFW, and therefore they need this services back
in the parent
in the
department.
parent department. And she has completed more than 5 years of service.
Here. Your rule is maximum is.
Not 5 years, my lord,
5
as
years.
per rule 50 of KCSR.
But absorption application ಏನ್ ಮಾಡ್ತೀರಿ?
My lord, that's in a separate matter, my lord.
But
And that is
ಅಲ್ಲಿ
clearly
ವಾಪಸ್
covered by
ಹೋಗಿದ್ದಾರೆ
PU
ಅನ್ಕೊಂಡು
Joshi
reject
case, my lord.
ಮಾಡಲ್ಲ.
PU Joshi case clearly applies to that case, my lord.
No, anyway, their application is being fought in the KAT now.
Please.
Because he is sent back. On that ground, you cannot reject that. If you assure that,
Indeed, my
then
lord.
we'll do something. Otherwise, she will be put to
Please, my
death.
lord, this may not come in the way of her seeking absorption if she is entitled to in accordance with law.
Because already she has applied for absorption.
Indeed, my lord. She has applied.
You consider that application immediately. Why unnecessary? That matter is pending. We'll do that here also. Their application for absorption. Are you not going to consider also?
ಅದನ್ನ ನೋಡಿಲ್ಲ ಸ್ವಾಮಿ ಅದರಿಂದ. This will not come in the way of for seeking regular absorption. in that.
One another ground which may kindly be seen in the impugned order, my lord, at page number 68, 66, my lord. Your last may kind.
ಯಾಕಂದ್ರೆ ಬೇರೆ ಅಬ್ಸಾರ್ಬ್ ಮಾಡಿರಿ ನೀವು ಈಗಾಗಲೇ.
My lord,
ಮಾಡಿದಾರೆ.
my lord, what happened?
1 second, please.
Nobody has been absorbed.
Nobody is absorbed. The other day you said someone is absorbed.
2-3 persons have been
To the
absorbed.
names.
Yes, my lord. Names are mentioned in the petition itself. Now, another ground which your lord may kindly consider, page number 66 in the impugned order.
It's 6.
ಏಕಕರ್ತಲ ಪ್ರಸ್ತಾವನೆ ಪರಿಶೀಲಿಸಾಯಿತು ಅದರಂತೆ ವಿದ್ಯಾರ್ಥಿಗಳ ಶೈಕ್ಷಣಿಕ ಮತ್ತು ಸಂಸ್ಥೆಯ ಆಡಳಿತ ದೃಷ್ಟಿಯಿಂದ ಶ್ರೀಮತಿ ಮಮತಾ ಜಿಸಿ, ಡಾಕ್ಟರ್ ಸರಸ್ವತಿ, ಡಾಕ್ಟರ್ ವಿ ನಾಗರತ್ನಮ್ಮ, ಡಾಕ್ಟರ್ ರೆಡ್ಡಮ್ಮ, ಡಾಕ್ಟರ್ ಜ್ಯೋತಿ, ಡಾಕ್ಟರ್ ಜಯಲಕ್ಷ್ಮಿ ಅವರನ್ನು ಕೂಡಲೇ ದಿಸ್ ಇಸ್ ದಿ ಆರ್ಡರ್. ನೌ ಯು kindly see page number 213, my lord.
No, Mr. Sridhar, we are asking you.
Yes,
What
these are-
is your right to continue in deputation?
My lord, according to the medical college, medical department rules, which I have produced at, my lord, page number 249. Kindly see page number 249.
249.
Yes, my lord. At 250, my lord.
ಏನು?
Lecturer, College of Nursing ಗೆ by promotion from the cadre of nursing tutor, if no suitable person is available for promotion in the cadre of nursing tutor, by promotion from the cadre of senior staff nurse, if no suitable person is available for promotion in the cadre of senior staff nurse, for promotion must be a master's degree in nursing or possess equivalent qualification recognized by the Indian Nursing Council, must have put in service of not less than 3 years in the cadre of nursing tutor, senior nurse. This condition we fulfill.
Correct, but they don't want you.
No, my lord, that is a different aspect. Now, my lord, what they have done, my lord, the nurses working in the institute who have been asked to work, my lord. The other ground which I wanted to emphasize is page number 213, kindly see.
213.
213.
What is your right
213.
of-
Page number 213, my lord. A24.
ಅಲ್ಲೇ HP ಲಕ್ಷ್ಮೀ ನಾರಾಯಣ ವರ್ಸಸ್ KFDC ಕೊಡ್ರಿ.
Page 213, my lord.
Justice Sridhar Rao ಕೊಡಿ. ಇದೇನು 213?
Yes, my lord.
ಸರಸ್ವತಿ ಸೈನ್ಸ್.
Dr. Saraswati, clinical psychologist, so and so. Her name found in the impugned order. ಮೇಲ್ಕಂಡ ಸರಸ್ವತಿ ಕ್ಲಿನಿಕಲ್ ಸೈಕಾಲಜಿಸ್ಟ್ ಮತ್ತು ಮಾನಸಿಕ ಆರೋಗ್ಯ ವಿಭಾಗ ಮುಖ್ಯಸ್ಥ ದಿನಾಂಕ 19 ಉಪರಾಹ್ನ ಈ ವಿದ್ಯಾಲಯ ಕರ್ತವ್ಯ ಮಾಡಿಕೊಂಡಿರ್ತಾರೆ.
ಅಬ್ಸಾರ್ಪ್ಷನ್ ಅಲ್ಲಿ.
No, she has taken back. Is in the same.
What is your right?
No, my lord, on the ground that there were no professor working in the department, she is there. That is one aspect. Another one is, my lord,
Yes.
one K. Mallu has been absorbed.
ನಿಮ್ಮ ಅಬ್ಸಾರ್ಪ್ಷನ್ ಇಂಡಿಪೆಂಡೆಂಟ್ಲಿ ನಾವು
ಆಗ್ಬೋದು. ಆಮೇಲೆ ನಾನು
ಬೇಡ.
ಇನ್ನೂ ಒಂದು ಪಾಯಿಂಟ್ ಏನಂದ್ರೆ ಇವ್ರು ಲಾಸ್ಟ್ ವೀಕೆಂಡ್ಲಿ ನಾವು ಐ ಫೈಲ್ಡ್ ಅನ್ ಅಫಿಡವಿಟ್ ಲೀವ್ ಅಪಾರ್ಟ್ ವೆದರ್ ಐ ಗೋ ಟು ಹೆಲ್ತ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಆರ್ ನಾಟ್. ನೌ ವಾಟ್ ಹ್ಯಾಪನ್, ಮೈ ಲಾರ್ಡ್, ದಿಸ್ ಕಾಲೇಜ್ ಹ್ಯಾಸ್ ಲಾಸ್ಟ್ ಇಟ್ಸ್ prestige of holding a center because of non-qualified teaching staff. That order I have produced along with the list.
You are concerned. If it
My lord,
was state-
and now who are posted in our place is that, my lord, the nurses working in the institute.
You mean to say government does not understand at all?
No, my lord, the nurses working in the institute cannot be posted in view of the specific.
ಅವನ್ set aside ಮಾಡೋಣ. But what is your right?
Alla, if they goes, my lord, nobody remains in that institute.
It's
That,
the employer's prerogative.
My lord, you Rashmi
Correct.
kindly consider that aspect.
Commissioner,
I filed
instead
a
of
affidavit saying that
knocking at the doors of writ court for assailing the State Administrative Tribunal's order dated 14 February 2025, whereby her two
Madam,
application
Madam.
numbers 3539 of 2004 and 4746 of
He is anxious, my lord.
2004.
Sir,
All right, your lawyer is a fresh.
ಸತ್ಯಾಂಶನೇ ಬೇರೆ ಇದೆ ಸ್ವಾಮಿ.
ಆಗ್ಲಿ
ಸ್ವಾಮಿ, ಇಲ್ಲಿದೆ ಸ್ವಾಮಿ.
ಅದು ಏನದು ನ್ಯೂಸ್ ಪೇಪರ್
ಅನುಮತಿ
ಬಲಿ-
ಕೊಟ್ರೆ
ಬಲಿಪಶು
ನ್ಯೂಸ್ ಪೇಪರ್
ಬಲಿಪಶು ಮಾಡಿದ.
ವರ್ಕ್ ಮಾಡಿದ್ದೀನಿ
ನ್ಯೂಸ್ ಪೇಪರ್ ಯಾರ್ದು
ಇರೋದಕ್ಕೆ ಪ್ಲೀಸ್ ಸ್ವಾಮಿ.
ಕರೆಕ್ಟ್ ಅಮ್ಮ ನ್ಯೂಸ್ ಪೇಪರ್ ಹೆಂಗ್ ನೋಡೋದು ನಾವು ನೋಡಬಾರ್ದು ಅಂತ ಹೇಳಿದೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್
ಸ್ವಾಮಿ ಇದೆಲ್ಲ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ಆ ಪ್ರಕಾರ ಎಲ್ಲ ಆಕ್ಷನ್ ತಗೊಳ್ಳಿ ಅವ್ರು ಯಾರ್ಯಾರ ಮೇಲೆ ತಗೋತಾರೆ
ಯಾರನ್ನೋ ಕರೆಸ್ತಾರೆ ಸ್ವಾಮಿ, ಎಕ್ಸಾಮ್ ಬರ್ಸ್ತಾರೆ. ಅವ್ರನ್ನ ಡೆಪ್ಯೂಟಿ ಆಗಿದ್ದೆ ನಾನು. ಮತ್ತೆ ಬೆಳಿಗ್ಗೆ ಅವ್ರನ್ನ ಕರ್ಸ್ಬಿಟ್ಟು ಆಲ್ ಟಿಕೆಟ್ ಇಲ್ಲ, ಮತ್ತೆ ಇದು ID ಕಾರ್ಡ್ ಇಲ್ಲ, ಬರ್ಸಿ ಅಂತಾರೆ ಎಕ್ಸಾಮ್. ಬರ್ಸ್ಬಿಟ್ಟು ಆದ್ಮೇಲೆ ನಮ್ ತಲೆ
ಅದ್ರ ಮೇಲೆ ಬೇಕು ಆಕ್ಷನ್ ತಗೊಳ್ಳಿ ಅವ್ರು.
ಅವ್ರ ಮೇಲೆನೆ ಬರ್ಕೊಟ್ಟಿದ್ದಕ್ಕೆ ಇವಾಗ ನನ್ನ ರಿಪ್ಯಾಟ್ರಿಯೇಟ್
ಏನೇ ರಿಪ್ಯಾಟ್ರಿಯೇಷನ್ ನಿಮ್ ಯುವರ್ ಲಾಯರ್ ಇಸ್ ಎ ಸೀನಿಯರ್ ಲಾಯರ್ ಆಫ್ ಸರ್ವಿಸ್ ಲಾ. ಹಿ ನೋಸ್ ಹಿ ಇಸ್ ಎ ಮೋಸ್ಟ್ ಸಾಫ್ಟ್ ಆಫ್ಟರ್ ಲಾಯರ್ ಇನ್ ಸರ್ವಿಸ್ ಲಾ ಅಂಡ್ ಸ್ಟಿಲ್ ಯು ವಾಂಟ್ ಟು ಆರ್ಗ್ಯೂ.
ಇಲ್ಲ ಅದ್ರಲ್ಲಿ ಇಲ್ಲ ಪಾರ್ಟಿಗೆ ಅನ್ಯಾಯ ಆಗಿದೆ ಒಂದು.
ಆಗಿದೆ ಕರೆಕ್ಟ್.
ಈಗ ತಾವು ಒಂದ್ ವೇಳೆ ಕೇಳಿದ್ರೆ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಈ 5 ಜನ ಬಿಟ್ರೆ ಬೇರೆ ಯಾರು ಇಲ್ಲ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಇದ್ದವರು. Deputation is a different. We have got a right to continue here, and we are.
What's your right to continue after 5 years?
Because of even now it is a health department. Health department has not passed any order. Medical education department wants to send it back, but health department does not want. They have not passed order.
To which department this gentle lady belongs?
Health.
It belongs to Department of Health and Family Welfare.
Health and Family Welfare.
Please.
Who recalled her, cancelled her deputation?
My lord,
Which department?
it is the borrowing department, which is the medical education department.
Said that we don't want.
Please.
Where is that?
The-
My lord.
ಒಂದು ನಿಮಿಷ ಅವ್ರು ಏನೋ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಬೇಡ ಅಂತ ಹೇಳಿದೆ.
ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ?
My lord, annexure A10, my lord.
810.
Please.
Impugned order.
At 65, my lord.
$65.
Please.
ಇದು ಯಾರ ಲೆಟ್ರು ಯಾರಿಗೆ?
Impugned order.
My lord,
ಇದನ್ನ ಯಾರಿಗೆ ಬರ್ದಿರಿ ಇವರು?
my lord, it is written to the autonomous institution,
It is
which is
written by.
which is under the supervision of the medical education department.
Medical education. Not by health.
Madam is not from medical education.
It is from the
Health department.
Department of Health and Family Welfare. She was brought on deputation.
Who
because-
sent? Deputation is a tripartite arrangement.
Please.
Lending department, borrowing department, borrower, that the candidate. It's a tripartite arrangement.
Please.
If any one of them do not want, then ordinarily the
Please.
repatriation
Yes.
happens. But where is the
Concurrence
lending
of the
department?
Health and Family Welfare Department.
ಎಲ್ಲಿದೆ?
ಎಲ್ಲಿದೆ? ಇಲ್ಲ ಸುಮ್ ಇಲ್ಲ.
ಹೆಲ್ತ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇದ್ದಾಗ ನಾನು ಬಂದಿದ್ದೀನಿ ಸರ್.
ಹಾ, HP Lakshminarayan versus so and so. They should go back to the parent department. ಈಗ ಟ್ರಿಪಾರ್ಟೈಟ್ ಅರೇಂಜ್ಮೆಂಟ್ ಅಂತ ಹೋಲ್ಡ್ ಮಾಡಿ ಜಸ್ಟಿಸ್ DA ದೇಸಾಯಿ ಆಫ್ ಗುಜರಾತ್ ಹೈಕೋರ್ಟ್. ವೆರ್ ಇಸ್ ದಟ್? ಸಮರಾದಿತ್ಯ ಪಾಲ್ ತರಿಸಿ ಬುಕ್. ಸಮರಾದಿತ್ಯ ಪಾಲ್ ಆನ್ ಸರ್ವಿಸ್ ಕೊಡಿ, ಕೊಡಿ ನೋಡಮ್ಮ. ಡೆಪ್ಯುಟೇಷನ್ ಮೇಲೆ ಸಪರೇಟ್ ಚಾಪ್ಟರ್ ಇದೆ, ಕೊಡಿ. ಸಮರಾದಿತ್ಯ ಪಾಲ್ quotes Gujarat judgment of Justice Desai saying that ordinarily deputation is a tripartite arrangement. The lending department, borrowing department, and the employee concerned. If it is brought about, how third party will do it unless rules authorize?
Based on the direction of the education department.
But she belongs to
health
department. ಹೌದು, ಹೆಲ್ತ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ನವ್ರಿಗೆ ಅವ್ರಿಗೆ ಡಿಸಿಷನ್ ತಗೋಬೇಕು. ಅವರು ಬಾರೋಯಿಂಗ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಶುಡ್ ರೈಟ್ ಟು ದಿ ಹೆಲ್ತ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್.
I want to see that part. That record
That's not the settled position of law. ನೋಡ್ರಿ ರಾಮ ಜೋಯ್ಸ್ ಆನ್ ಸರ್ವಿಸಸ್, ಸಮರಾದಿತ್ಯ ಪಾಲ್ ಆನ್ ಸರ್ವಿಸಸ್ ಎರಡು ಇಡ್ಬೇಕಿಲ್ಲ. ಯಾವ ಮಿನಿಸ್ಟ್ರಿ, ಯಾವ ಡಿಪಾರ್ಟ್ಮೆಂಟ್?
Medical.
That is what they are saying now. I do not belong to medical education at all. I belong to
Health and.
family welfare ಅಂತ ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು. ಟ್ರಿಪಾರ್ಟೇಟ್ ಅರೇಂಜ್ಮೆಂಟ್ ನಲ್ಲಿ ಕೂಡೋದೇ ಇಲ್ಲ ಅದು. ಏನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. ನೀವು ಅದನ್ನ ತೋರಿಸಿದ್ರೆ ನಾವೇನಾರ ಮಾಡ್ತೀವಿ ಅಷ್ಟೇ. ಪಾಯಿಂಟ್ ಓದಿದ ಪಾಯಿಂಟ್ ಬಿಡಿ. ಯಾರು ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಹಂಗಾಗತ್ತೆ, ಶಿ ಇಸ್ ನಾಟ್ ದಿ ಗಾರ್ಡಿಯನ್ ಆಫ್ ದಟ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್. ಬಟ್ ಟ್ರಿಪಾರ್ಟೇಟ್ ಅರೇಂಜ್ಮೆಂಟ್ ಇದ್ದಾಗ when you want to send her back, you should take the permission of the lender. ನಿಮ್ಮಲ್ಲಿ ನೀವು ಸಮರಾದಿತ್ಯ ಪಾಲು, ರಾಮ ಜೋಯ್ಸ್ ಮಗ್ಲಲ್ಲಿ ಇಟ್ಕೋಬೇಕು. ಇಟ್ಕೋಬೇಕು. ಅದ್ರಲ್ಲಿದೆ ಸಮರಾದಿತ್ಯ ಪಾಲ್ treats deputation as a chapter. So beautifully he has written it. ಏನ್ ಮಾಡಕ್ ಬರಲ್ಲ. It is written to somebody else.
But regarding the whether there is concurrence by the Health and Family Welfare Department, can I get some time till 2:30 in the afternoon?
ತೋರಿಸಿ
6 months.
Please.
ರೂಲ್ಸ್ ಪ್ರಕಾರ ಮಾಡಿ. ಪ್ಲೀಸ್ ಅಲ್ಟಿಮೇಟ್ಲಿ ಅವ್ರ ಆರ್ಗ್ಯುಮೆಂಟ್ ಇರ್ತಾರೆ ಹೇಳಿ, ರೂಲ್ಸ್ ಹೆಂಗಿತ್ತು ಅಂದ್ರೆ. ಆಮೇಲೆ ಎಲ್ಲೋ ಒಂದ್ ಕಡೆ ಸ್ವಲ್ಪ ವಿಕ್ಟಿಮೈಸ್ ಮಾಡ್ದಂಗೂ ಮಾಡ್ತಾ ಇದಾರೆ ನಿಮ್ಮವರು. ಎಲ್ಲ ಸ್ವಲ್ಪ ವಿಕ್ಟಿಮೈಸೇಷನ್ ಆದಂಗಿದೆ ಆ ಲೇಡಿ.
Milord, maybe
Don't help.
tomorrow, Milord.
Tomorrow, all right, tomorrow.
2:30, I've got some part of matter.
All right. Tomorrow ಬರ್ರಿ, ಪಾಸ್ ಓವರ್ ಮಾಡ್ಕೊಡ್ರಿ. ಓಕೆ. ಏನೋ ತರಿಸ್ಬಿಡ್ತಾರೆ ಇಮಿಡಿಯೇಟ್ಲಿ. ಅದೇನು ಮಧ್ಯಾಹ್ನ ಇದ್ಬಿಟ್ರೆ ಆಗಿ ಹೋಗ್ಬಿಡ್ತದೆ. ಮತ್ತೆ ಯಾಕೆ ಬರ್ಬೇಕು ಅವರೆಲ್ಲ?
ಅಲ್ಲೊಂದು ಮ್ಯಾಟ್ರ್ ಇತ್ತು, ಅಷ್ಟಕ್ಕೆ ಇನ್ನೇನಿಲ್ಲ.
tomorrow. ಅದನ್ನ ತೊಗೊಂಬರ್ಬೇಕು. ಸಮರಾದಿತ್ಯ ಪಾಲ್ ಜೆರಾಕ್ಸ್ ಮಾಡ್ಕೊಂಡು ತೊಗೊಂಬರ್ಬೇಕು ಆ ಪೇಜಸ್ ಅನ್ನು.
Take notice for respondent number 2, my lord.
P. Mali Patil, the panel counsel, is requested to accept notice for second respondent.
ಕೊಡ್ತೀನಿ. ನಾನು ಯಾವಾಗ
Government advocate,
Delay in the matter.
Notice.
number 9, Arvind V. Chavan,
Lord, there is a delay in this matter.
Notice.
Ravi Raghavan. Notice
ಆಗಿದೆ.
Ravi Raghavan.
Will condone delay, brother. 166 days ಇದೆ. ಒಂದು ಚಿಕ್ಕ ಬುಕ್ ಕೊಡಿ. Appeal is filed with delay. Application is filed seeking its condonation. First stop. It is supported by an affidavit. Delay is not too long. And explanation offered is plausible. First stop. In the above circumstances, application is allowed and delay of 166 days is condoned, subject to the condition that the appellant shall present ಯಾವ ಪುಸ್ತಕ Key to Indian Practice by Mullah to Bar Association Library, a set of 2 books, namely Key to Indian Practice by Dinsha Mullah,
High Court
DF
and civil.
Mullah, to High Court, to Trial Court.
Trial court and
Library.
civil.
High Court. Yes, next.
My lord, next matter,
Ah.
there is a short delay of 8 days notices.
Notice.
I'll take notice, my
My
lord.
learned friend would accept notice.
Sri accepts notice. Appeal is filed with delay of short delay of 8 days. Full stop. Application supported by affidavit. Offers explanation which is found plausible. Full stop. In the above circumstances, application is allowed, delay is condoned. Next, please.
Number 11, A. Sanmati.
It was adjournment. Disable ಆಗಿದ್ರಿ ಅಂತ ಅರ್ಜನ್ ಆಯ್ತು ಮೆನ್ಷನ್ ಮಾಡಿದಾಗಿದೆ. Serial number 3.
11 alva. 11.
Connected with.
Not before. Not before me. Not before us. Yes.
Serial number 12, A.R. Pradeep.
Fellowship, today only I have received the copies, my lord. I will file objections within 2 weeks, my lord.
You will file objections.
Yes.
But your long delay also we have condoned whenever you were here.
In this case, what has happened? The
Done.
tribunal remanded the matter. After the remand, the AO has passed the order. So it has been acted upon. Now they are challenging the original order.
What happened, Lordship, the tribunal sent back to the AO saying that give proper opportunity. While doing so, they also said the right to cross-examination is a secondary right and not to be given. My only question is because the AO passed an order ignoring the direction of the tribunal, also conflicting direction. So my only request is that I must be given a right of cross-examination.
Lordship, no fresh order has been passed. It is an appealable order.
Now already fresh order is passed.
They are burdened by the fresh order has been passed, ignoring the right to cross-examine by.
That's all right. That order you should challenge.
Lordship, the problem is the right to cross-examination denial has come from the tribunal order. Any authority will follow the tribunal order. If I am unburdened with that observation or a decision of the tribunal, this matter can go back to AO and give me opportunity and then pass an order. That's all.
No, now, after the remand, after passing a remand was treated, order is passed.
Yes. That order also I have brought before Lordship. Why the delay is because I waited for the.
Delay. We are on the question only.
Yeah.
That order, you can challenge, we will keep open the your right to cross-examination to be
Yes.
urged as a ground.
Yes, sir. And also jurisdiction is there, 148 notice validity also. If these two are kept open.
We'll keep open
And,
let
Lordship-
him argue those points.
Lordship, one last sentence. If this is given, the order passed by the AO suffers from these two lacunas of non-consideration. So if the AO order also set aside, direct the AO to give me this.
Have you challenged that AO's order?
Yes, it is, I have sought for because this is a consequence of the tribunal order.
Have you challenged that order?
Before Lordship, I have enclosed for a IA, for a stay on that. Once the Lordship clarify, the order of the AO becomes infractious.
No, does not become infectious. Once an order is passed by a statutory authority, unless it is set aside in
Yes,
accordance
I agree,
with law,
Lordship.
it remains valid. AR 1992, Supreme Court, page 111, paragraphs 5, 6, 7.
I go before your Lordships.
Therefore, this appeal is not maintainable.
No, in so far as the clarification, once the clarification is given,
Appeal is not maintainable in against the order in order concerned in as much as in terms of said order, matter having been remanded, a fresh order has been passed by the AO. First off, therefore, it is open to the assessee to challenge that order, taking up all grounds, including the right to cross-examination
and also issue of jurisdiction.
and jurisdiction as well.
All issues are kept open.
First, in the above circumstances, appeal is dismissed. Without hesitant perspective.
Lordship, can it be said as allowed as parade instead of dismissed,
Disposed of.
Your Lordship, since it's not maintainable, my lord,
They disposed of. Therefore, we said that all other contentions are, no, all contentions of
Amen.
parties are
of
kept.
both the parties.
Both the parties are kept. open.
all contentions. Much obliged.
Number 13, YV Raviraj, 13 to 20.
12 days.
We'll take notice.
Tanvi Rajkumar,
Yours of notice,
13 to 20.
13 to 20. ಎಲ್ಲದರಲ್ಲೂ 12 days. We'll condone 12 days.
Same respondent.
All right. Short delay of 12 days is condoned by allowing application supported by affidavit. Okay.
Same,
Affidavit. Explanation being plausible. Okay.
the question of law, my lord, in the same case of the respondent, my lord, it has been admitted. It's a group matter,
Group matter. 30.
all matters.
The appeal is admitted with the following substantial questions of law. ಅಲ್ಲಿದೆ ನೋಡಮ್ಮ. ಎಲ್ಲರಲ್ಲೂ ಇದನ್ನೇ ಮಾಡಬೇಕು. ಕೆಳಗಡೆ note. This court in a matchable fact matrix, namely ITA number 49/2025, has admitted the appeal. First, it's not matter. Call this matter along with.
Please.
ನೋಡಮ್ಮ ಎಲ್ಲದರಲ್ಲಿಯೂ ಒಂದೇ ಅಷ್ಟು call my book.
Same.
All. Call all these matters together as club.
Number 21, Arvind Vichavan.
At serial number 21, 78 days delay, emergent notice may be.
Emergent.
Number 22, Srini Rajgopal.
Yes.
Respondent by me, my lord, we have filed an application for vacating the interim order.
Huh.
Here, what has happened is, my lord, there was a Tahsildar was, my lord, posted in Bangarpet. Did not attend, my lord, the office regularly. Deputy Commissioner, my lord, initiated action. Thereafter, my lord, the MLAs also, my lord, the people went to the MLA and complained. MLA also complained. Ultimately, Chief Minister said, from Bangarpet, you go to Kolar, Alva. And he challenges it before the KAT. Thereafter, my lord, having lost, he comes before your lordships. We have, my lord, he had obtained.
Kindly seek for a short passover. My lord. Senior is here only.
Passover.
Senior is
Passover
from-
ಬೇಕು ಅಂತಾರಲ್ಲ.
Senior
Next
is
week,
here.
next week ಹಾಕೋಣ.
No, my lord. My lord, senior is here only.
Here only.
Two.
Bring it.
2 months. Please, my lord.
Passover.
Number 23, A. Sanmati.
Transfer pricing issues, Supreme Court remand matter, question number 1 to 4 required.
ನೋಡಮ್ಮ, admitted on question numbers 1, 2, 3 and 4.
Please.
Note ಹಾಕೋಬೇಕು. Similar matters are being debated. Yes.
Number 25, A. Sanmati.
The book has been produced, my lord. It may be adjourned for 4 weeks, my lord. A memo may be accepted, my lord. Books has been, officer,
Memo is accepted.
it may be adjourned for 4 weeks, my lord. Review petition is pending.
Call after 4 weeks. As requested.
Number 26,
It's a very famous book, God Delusion, by Richard Dawkins, one of the famous authors of evolutionary biology. His discussion, etc. in YouTube, you will find. Very beautiful books he has written. Selfish Gene, The Blind Watchmaker, Magic of Reality. On him itself, there are 7 books about author himself. He was recommended for Nobel Prize. Then because of some statement he made, it was not accepted. A great author. Yes.
My lord, this questions of law at page 29 is whether, page 29, my lord.
What is this matter about, Mr.
Matter is
Shankar?
about whether I am registered under the 12A of the Income Tax Act from 18/12/98, and I've been given section 11 exemption. For these 2 years, they have not given me exemption. But for the assessment year 14-15, which the tribunal remanded it, for these 2 years, the tribunal did not remand it. On remand, they have granted me again exemption under 11. Only for these 2 years alone, they have not given me, my lord. All the decisions which I cited have been distinguished. Our major thing, my lord, is that we come under 11 and we have got exemption right from 1998 till date. So consequently, questions of law arise. 2 years of aberration has happened. Activity has not changed any of the years. Questions of law at page 29, para 20, 21, 22 may require consideration.
What is the question of law you have framed?
For the immediate earlier year 14-15, they remanded back, and on remand, the officer has granted me.
No, what is the reason for not granting that for the consent 2 years? What's
The
the
facts are
reason?
the same. They are saying the activity of what we am doing and doing self-help groups and various, we are actually come.
Where is
under-
the reasoning part?
That I'll tell you, my lord. Before that, I'll tell your lordship. What the assessing officer says is, I have got registration under 12A. He has applied section 215 of the Income Tax Act. If your lordship would look at section 215, it is applicable only to the last limb of charity, that is object of general public utility. Whereas in my case, I have come within the category of relief to the poor. So the question, that is my question number 2, my lord. At para 21, if your
Let
lordship
us-
just run through
Let us
21.
read the law.
Yes, my lord.
Which page?
Page subsection, I mean, so 215, 1.10, my lord.
0.10.
Lordship got it, my lord? 2 subsection 15. Charitable purpose, left side of it. Left-hand side. of it.
0.9, 1.10.
10.
Yes.
Charitable purpose, that is subsection
Purpose
15.
includes
Includes relief to the poor, education, yoga, medical relief, preservation of
Preservation of
environment,
environment,
forest,
watersheds.
preservation of monuments, places, and advancement of other objects of general public utility. That is the last limb.
Object
Now-
of general public utility
That
is
is what-
aegis generis.
Is just some general.
Ah.
But Your Lordship, you see the proviso. Provided that the advancement of any other object of general public shall not be charitable if it involves carrying on any activity in the nature of trade.
What is meant by provide?
What the
Provided
proviso
that the
means, my lord,
advancement of any other object of general public
that is the last limb.
utility.
If it
shall not
involves
be a charitable, if it involves the carrying on of
any activity in the nature of trade, commerce, or business,
business
or any activity of rendering any service in relation to any trade, commerce, or business, for a cess or fee or any other consideration, irrespective of the nature of use or application or retention of the income from sale.
You fit into what? Which component of
I,
250?
my claim all years have been allowed under includes relief to the poor.
Where is that? You are a trust, you are a deed? Show that.
Trust deed, my lord, page 51 may be seen, some objects have been reproduced.
Where is that?
1 minute.
Your case is that you do not fit into registry clause at all. So in which of the clauses you fit into? Just show
the
that.
poor. Para 53, page 53, para 6.4, main objects, clause A.
Page
Page 53, it is reproduced, my lord. 53,
53.
yes, my lord.
Paragraph
Paragraph 6.4 below.
6.4 below.
Your lordship will see 614. My object, to carry on and take the financing and providing credit on interest on otherwise group persons belonging to the poorer sections and joined together based on concept of self-help group. So my, right from beginning from 98, I'm doing only this. And for a moment may also be see page 216, my lord.
Prior to adding proviso to section 215 of the Act, the entities which got registration on 12A of the Act engaged in commercial activity claimed exemption on the ground that such activities were the advancement of object of general public utility in terms of fifth limb of definition to section 215. We find that the said benefit was taken away by adding proviso to rule, notice section 215 of the Act. There is change of legal regime.
Yes, my lord.
Wherein it explains that advancement of any other object of general public utility shall not be charitable purpose.
217.
Two?
Page 217, your lordship may take. That the board circular itself has clarified.
No, they have operated the proviso.
They operate the proviso when I don't fall in that limb. That is the question. My case.
You don't go to the last line of the first part of the definition at all.
Yes, that is my case. Basically because your lordship may see page, because I am doing this object to poor right from
ಅಲ್ಲ ಪೂರ್ ಅನ್ನೋದು ಎಲ್ಲಿದೆ ನಿಮ್ಮ ಇದ್ರದ್ದು ತೋರಿಸಿ ಓದಿ
6.4 al madam, main first object.
6.4 ನಲ್ಲಿ ಫಸ್ಟ್ ಆಬ್ಜೆಕ್ಟ್
A subclass, capital A, all small a. To carry out and undertake financing and providing credit on interest or other way to group of persons belonging to poorer sections of section joined together based on concept of self-help. That is what it is, and we have been getting on this head right from 98.
No, that time law was different.
No, law is not different. Even then poor was there. In 98 also there were 4 limbs. That is poor, education, and 4. Now it has become 8. The lordship had to read 215 of the Income Tax Act. Even in 98, 4 limbs were there. Advancement of object of general public utility is there since the time 1961. Then environment, all those things got added.
Which point ನೀವು ಓದಿದ್ದು ಪೂರ್ ಅಂತ ಇರೋದು ಯಾವ ಪಾಯಿಂಟ್ ನಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ ಆಫ್ ದಿ ಯುವರ್ ಅಪೀಲ್ ಮೆಮೊ
53, sir. 53.
6.4.
ಅಲ್ಲಿ ಪ್ಲಾಸಿಡಮ್ A, ಅದರೊಳಗೆ ಸಬ್ ಕ್ಲಾಸ್ A.
See, to carry out and undertake the financing and providing credit on interest
Yes, my lord.
or otherwise
Yes, my lord.
to group of persons belonging to the poorer sections joined
ಇಲ್ಲ
together
10,000, 6,000, 3,000 ಲೋನ್ ಕೊಡ್ತಾರೆ.
concept of self-help groups both in rural and urban areas with active support of non-government organizations based in India. No, if it is with the interest,
It is permissible in law.
it's permissible. That
Now, your
also-
lordship may see one more point, 217 may be seen, just to support my page 217.
of a book.
No, my lord, this, my appeal memo. Where the circular itself clearly says, if I come under the 4th limb, which is what your lordship will see,
217.
numerical 3, middle of the page.
Newly inserted provision.
Yes, my lord. The newly inserted provision to section 215 will apply only to entities whose purpose is advancement of any other.
That's all right.
No, I'm very
Such
clear.
entity will not be.
The fourth limb of the definition, at time it was fourth, now it is last, much more.
Carrying on
And-
activity in the native trade, commerce, business, sorry, based on extent.
It is applicable only if you fall in the fourth limb.
Correct. If you do not fall into, your case is that you do not fall into that at all.
That is the question of law raised at 29.
Correct. But that your first one at page 53, 6.4a,
Lordship,
does it amount to helping the poor?
based on this particular clause, I've been.
They have already granted.
Granted from 98 till today. And even on remand, they have granted me 1 year tribunal remanded, 2 years they did not remand. Page, para 20, 21, 22 will arise, my lord.
Paragraph 20.
Page 29.
The appeal is admitted on the following substantial questions of law. Page 29 is another. First, issue notice, emergent notice.
Chavan is.
Shri Chavan, the panel counsel is requested to accept notice for revenue. Then small point, very, very short point. After 4 weeks, October.
4 weeks.
Markopoda? After 2 weeks, Markotira. Is the point? Whether he fits into the residuary clause, then he will not fit at all. That is his case. But you treated it as under the residuary clause, and therefore you applied the proviso. Unless the residuary clause itself is applicable, the case will not travel to proviso at all, is his submission.
This is my case.
I fit into the substantive part of the.
And consistently for one of the immediate earlier years, tribunal remanded the matter to look into it, and the officer has looked into it and passed an order granting me registration under 11. Under exemption under 11. That is fortifying my contention. Obliged.
All right. After 2 weeks, Madi, stay.
3 weeks.
Settle that.
3 weeks.
3 weeks.
IPL match some
4 weeks. 4 weeks.
4 weeks.
All 4 weeks.
That should be my personal work.
Next.
Number 27, Arvind V. Chavan.
My lord, this is a customs appeal, my lord.
Huh.
The short question is that while filing application under section 27(1)(a), whether the assessee has to prove that the burden of the duty that he has paid has not been transferred to the customer. That is the case of unjust enrichment. Enrichment, my lord. Here, the assessee has filed an application, but however, he has not proved whether the burden has been transferred, the duty burden has been transferred to the customer or not. Because 28A clearly says the presumption is that you have transferred the burden, you have to disprove it, my lord. Now, the assessment
Burden is on the assessee.
burden is on the assessee. 28A clearly there is a presumption that the burden is transferred to the customer. He has to disprove it, my lord. Now he has to establish that, see, look, for this particular period, financial period, I have sold the product to the customer, but however, I have not transferred the burden. In this matter, my lord, in the financials for assessment year 2007-8, he should have incorporated in his returns as receivables because the burden is not transferred. But he says there is no receivables. For 8-9, there is a receivables. The Honorable Sess Tax says the chartered accountant has issued a certificate that burden is not transferred. That's enough. There is nothing more to prove. Now the question.
He stated in the column of receivables.
Yes, my lord.
He cannot take up that.
He cannot take up that
advantage.
Because it is like double benefit.
Otherwise, he will retain that money. He will pocket that money.
He will pocket that money from the customer and he will take refund from us also.
Correct. So, unjust enrichment apply.
Yes, please.
Question
of law at page 20, my lord, 1 to 4, my lord.
Nodama. Appeal admitted. Delay illa tane?
Delay.
The following questions of law, page 20.
1 to 4.
1 to 4.
Please.
Emergent.
Number 28, Jivan J. Niralgi.
Mr. Nilargi, some inconvenience he wants something.
2 weeks at the request.
Continuing matters, number 29, Shishira Amarnath. Pranay Sharma.
Same for the applicant.
Shishira.
My
Yeah.
lords, the primary issue in this case was whether the evidence gathered by an improper officer or an investigation or search and seizure conducted by an improper officer, or subsequently a proper officer can issue a notice, SCN, my lords. This is the primary question before this one.
Huh?
When an improper officer has conducted investigation, search and seizure, my lords,
Yes.
whether a proper officer, based on the information that's gathered through the improper officer's investigation, can he issue the show cause notice? This was the primary question, my lords.
Improper officer has a
Conducted search, seizures, drawn mahazas, and when he realizes that he does not have jurisdiction, he transfers the case to the proper officer, and proper officer, purely on the borrowed satisfaction, issues me a show cause notice, my lords. And
in American law, such cases they treat under a due process clause.
yes, ma'am.
If evidence is gathered contrary to law, though evidence is admissible, that evidence cannot be looked into is American judgment, American Supreme Court judgment.
Agreed.
But if evidence is gathered by an incompetent authority, but evidence is otherwise admissible in law, then the legality procurement will not arise is the apex, which goes against you.
Yes, my lords. In fact, in this, the Honorable Single Judge, my lords, in fact, has overlooked certain facts, my lords. The case was in fact transferred in the year 2021. The case was transferred to the proper officer in view of the fact that there was no jurisdiction, because it's a cross-border jurisdiction issue, my lords. Only during the part of the investigation, they came to know that they don't have the jurisdiction. And there's evasion to the tune of 27 crores.
We are asking a question now.
Yes.
If a person an official who has no jurisdiction conducts a search, raid, procures evidentiary material, whether such material can be acted upon by the revenue for issuing notice of the kind. That is the question.
My contention is no, my lords. Since the entire beginning inception of the process itself is void, subsequently whatever is happening is also void, my lord. And further, my lords, in this present case, what has happened was, I have also deposited an amount of 50 lakhs way back in the year 21, when the investigation was conducted by the Mangalore Commissionerate. And after a lapse of 2 years, they issue me a show cause notice. And it's a fresh show cause notice, not even for short paid, or they're stating that they're apportioning my whatever the deposits I have paid. It's an entirely new process.
Judgment is not money. Admissibility of evidence is one thing, its illegal procurement is another. Illegal procurement of evidence will not render it inadmissible per se. I think 71 Supreme Court irbodu. Ratan Lal, Dhiraz Lal on Evidence Act ide. Adral he has quoted this. Shankar yenide matter.
My only submission is on the subject matter which your lordship are asking. Collection of illegal evidence, there is a decision of the Supreme Court in Tribunal. It is 71 was said, but I know the IPR, where they said it can be used. But then subsequently in a Bombay High Court decision.
Beneath Kumar.
6 months back.
Beneath
They
Kumar.
said after the decision of the Supreme Court in the Kutswami case, Tribunal is no longer good law and the question cannot be used. That is the two divergent views available on the system.
Oh, I see. Thank you.
Bombay High Court also.
It's been rightly recorded. Single judge has recorded the
That judgment
That judgment is very much recorded.
But in America, Justice Black held where they had a person was convicted for an offense and indicted. That they had shown to the court that the procurement of evidence was tainted with illegality. That case they brought under due process clause, 4th Amendment to the American Constitution, and said that this is bad. But we differed from that in that 71 Supreme Court. There they said illegality of procurement of evidence is one thing, its legal admissibility is another. If it is otherwise shown to be admissible from section 5 to section 58 of the Evidence Act, then the procurement illegality will not come in the way. I remember that judgment. Our professor our great lawyer, IG Hiregowda, was our professor of law of evidence. He was a great professor, a great teacher, one of the greatest teachers on law of evidence. Great lawyer also out of Karnataka. He used to tell these things. Just look into. I'm telling it from memory of my college days. Memory may not be very dependable, but just look into.
Yes.
Next week,
Corridor.
Ah.
Here, two senior counsel were discussing.
not audible. You are audible. Your voice is not audible.
Only you are off the system, my lord. Morning, a few of our senior counsel were discussing, how do you get time to read so many books?
I don't have any other business at all. I don't have any other business except reading. Reading gives enormous pleasure. I was amazed. There are two volumes which Mr. Shankar may look into. Harold Lusky and Oliver Wendell Holmes letter correspondence. To that, Felix Frankfurter has written introduction. It runs into two volumes from 1917 to 1935 till his death. The discussion, enormity of depth,
And literature.
not one. The very letters themselves make lot of sense. He bitterly criticizes Oliver Wendell Holmes, saying that judge, you do not know. You have written a wrong judgment. Then on that discussion goes on. That itself is worth reading. He was Harold Lusky, the great author of ABC of Politics, Grammar of Politics. That great author was the closest friend of Oliver Wendell Holmes. The letter correspondence, great literature, and the introduction which Felix Frankfurter has written, that itself is a celebration. Just see whenever you get time. I will read. Yes. Yes. ಅಂತವೆಲ್ಲ ಓದ್ಬೇಕು. ಲಾಯರ್ಸ್ ಯಂಗ್ಸ್ಟರ್ಸ್ ಎಲ್ಲ ಓದ್ಬೇಕು. ಅವಾಗ ಮೈಂಡ್ ಅರಳುತ್ತದೆ, ಮನಸ್ಸು ಅರಳುತ್ತದೆ. ಓದ್ತಾ ಇರ್ಬೇಕು. Yes.
Interim order maybe.
My lords, I object.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ತನಕ ಇರ್ಲಿ. ಎಂಟ್ರಿ ಮಾಡಿದೆ ಈಗ.
ನನಗೆ refund ಬರ್ಬೇಕಾಗಿತ್ತು, my lords.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರ್ತದಲ್ಲ. ಓದ್ಕೊಂಬನ್ನಿ ಅಂತ ಅನ್ನೋದು ಟೈಮ್ ಕೊಟ್ಟಿದ್ದು. Since you have come
No, my lords.
without seeing
the refund
that,
part,
you bring
it's
that
just a-
American judgment also.
Definitely,
Let
my
us see,
lords.
much of American law has percolated into our law now.
Yes, my lords, but the refund part, let them at least, there should not be a stay, my lords. It's
Correct.
already 50 lakhs is with them since the year 20.
ನೆಕ್ಸ್ಟ್ ವೀಕ್
A date may be fixed, my lords.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಓದ್ಕೊಂಡ್ಬರ್ಬೇಕು. ಕಂಪೇರಿಟಿವ್ ಲಾ ನೋಡ್ಬೇಕು. Comparative law has a great advantage. See, we, on the advice of Felix Frankfurter, B.N. Rao did not include due process in Article 21.
Yes.
But Apex Court equated the procedure established by law to due process. In Rustum R.C. Cooper, it is virtually due process now. Justice Abhinav Chandrachud, Mr. Abhinav Chandrachud has written a very good book, Due Process. Wonderful book. Very book name itself is Due Process. Comparative jurisprudence, you will find that.
Grateful.
Number 30, Chetan AC.
VDA G category site, my lord. I've sought for writ of mandamus. Letter of allotment was given in 2009 itself, my lord. After that, they sent a notice that I didn't pay the cital value. I gave the DD, but they did not encash. Then after that, the committee was formed in the Justice Shailendra Kumar committee. I was cleared. I don't have any site in my native town. And now they took the DD from me 2022. Finally,
The category judgment was by Justice Nazir Saab.
They formed a committee, my lord.
Committee was formed.
Justice Shailendra Kumar committee, in that I produced. So now they have to allot the site. They have even some other person who did not pay the amount in time. They have passed a government order and they have given money that I have produced.
Take notice. Consider ಮಾಡಿರಿ ಅಂತಂದ್ರೆ ಸಾಕಾ?
Consider.
ಕನ್ಸಿಡರ್ ಮಾಡಬೇಕು ಅಂತ ನೋಡ್ಕೊಂಡು ಹೇಳ್ತೀರಾ ಅಥವಾ ಬರೀಬೋದ? ಕನ್ಸಿಡರ್
BDA has to,
BDA has to come.
essentially the direction will be given to the
Emergency
BDA.
notice. Learned AGA is requested to accept notice for first respondent. Karthikeyan is requested to accept for the BS Sachin. Panel counsel is requested to accept, learned panel counsel is requested to accept notice for second respondent. call this matter next week. Copy ಕೊಡಿ.
Let them not allot that site to somebody.
ಅಲರ್ಟ್ ಮಾಡ್ತಾ ಇದಾರ?
ಅಲ್ಲ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಏನ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅದನ್ನ ಕೊಟ್ಕೊಂಡು ತೊಗೊಂಬನ್ನಿ ಮುಗಿಸೇಬಹುದು.
Number 31, Prithvish.
Prithvish. ಏನಿದು?
Short for the direct.
ಕೊಡ್ತಾಯಿ. ತೊಳಿ. ಕೂತ್ಕೊಳ್ಳಿ. ಹಾ.
For a writ of mandamus.
Writ of mandamus to
the state government, to the Director General. State government had written a letter to the Director General. In fact, I'm so sorry. I had submitted certain objections. The state government forwarded to the Director General saying that please consider. The Director General in fact wrote back to the state government saying these are the facts. Please direct us how we have to proceed. State government in turn wrote back to the Director General saying that if you have to do this, you have to do so on, so on, so on, so forth. Which was not acted upon. So I made a request to the tribunal. State government has issued directions on the request of DG. DG has not acted upon. Please direct them to consider the letter of the state government. Now, tribunal would reject it.
On the ground?
Tribunal would reject it on the ground. If the letter written by the state government is considered, then it would affect a large number of persons and the seniority. Therefore, the letter written by the state government at the request of DG should not be considered by the DG. Ultimately, whether if somebody is affected, will not.
Tribunal comes to that conclusion.
Yes, Manoj.
Then that's a right conclusion.
Provided DG acts upon the state government.
No, you can't ask if it is acted upon.
Yes, Manoj.
Whether the consequences which the tribunal has mentioned
Yes,
will
Manoj.
ensure or not is the question.
No, Manoj.
It will not.
No, Manoj. Because
How?
the state government DG requests, Manoj.
My lord, essentially, the challenge is to the 2015 seniority legislation.
No, Manoj. It's not to that.
That is the finding of the tribunal.
Yes,
That
that
has
is
to
what
be
I'm
redone.
challenging.
Malcolm Lawrence case covers this issue, my lord.
In fact, your lordship's latest judgment, may I just draw your lordship's attention to page 105 minutes.
105.
Yes. This is the letter. On 11/7/24 minutes. Ulleka. ಶ್ರೀ ಹನುಮಂತರಾಯ್ ಸೋನ್ಸೋ ಹಕ್ಕು ಜಾರಿ ನಿರ್ದೇಶನ ಸೋನ್ಸೋ ಮನವಿ ಪತ್ರ ಇದೇ ಸಮಸಂಖ್ಯೆ ದಿನಾಂಕ ಸೋನ್ಸೋ ತಮ್ಮ ಕಚೇರಿ ಪತ್ರ ದಿನಾಂಕ 24/4/2024. That is the letter of the DG, which your lordships, my lords, would find at page 97. 97 it starts, A9. May I just draw your lordship's attention, my lords? He would narrate all the facts. Page 104, my lords.
This letter is sent by whom to whom? This
By-
is to the additional chief secretary.
By the DG, page 104, my lords.
What he says,
My lords, page 104. May I just
ಆದ್ದರಿಂದ
last sentence, may I just. ಇಲಾಖಾ ವಿಚಾರಣೆ ಬಾಕಿ ಮುಂಬಡ್ತಿ ಪರಿಗಣಿಸುವುದೆಂದು ತಿಳಿಸಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ನ್ಯಾಯಾಂಗ ನಿಂದನ ಅರ್ಜಿ ಸಂಬಂಧವೂ ಸಹ ಸರ್ಕಾರ ಹಂತದಲ್ಲಿ ಪರಿಶೀಲಿಸಿ ಸೂಕ್ತ ಕ್ರಮ ಕೈಗೊಳ್ಳುವಂತೆ ಕೋರಲಾಗಿದೆ. Mallards, he would request the government, Mallards, to please give us a direction to proceed in the matter. It is at the request of DG himself.
not DG,
Let's
additional IGP.
additional IGP. Let's left side alle DG ಮತ್ತು IGP ರವರಿಂದ
ಅನುಮೋದಿಸಲ್ಪಟ್ಟಿದೆ. You are
Yes.
right.
Let's in response to that, page 105 is the letter, Mallards.
ಅವ್ರು ಏನಂತಾರೆ?
Last portion, page 105 ಅಲ್ಲಿ.
ಆದ್ದರಿಂದ ಡಿಜಿ ಮತ್ತು ಅಧಿಸೂಚನೆ ನಂಬರ್ ಸಾಕಷ್ಟು ಕೂಡಿದ್ದು
ಈ ದೋಷ ರೂಪಿತ ಅಂತಿಮ ಆಧರಿಸಿ ಸರ್ಕಾರದ ಅಧಿಸೂಚನೆ ಸಂಖ್ಯೆ ವೃಂದದ ಮುಂಬಡ್ತಿ ನೀಡುವ ಲೋಪದಿಂದ ಈ ಕುರಿತು ಸ್ಪಷ್ಟೀಕರಣ ನೀಡುವಂತೆ ಕೋರಲು ಹಾಗೂ ಜ್ಯೇಷ್ಠತಾ ಪಟ್ಟಿಯನ್ನು ಪುನರ್ ಪರಿಶೀಲಿಸಿ ಪ್ರಕಟಿಸಲು ಸಿವಿಲ್ ವೃಂದಕ್ಕೆ ನೀಡುವ ಮುಂಬಡ್ತಿಯನ್ನು ಅಗತ್ಯ ಅವಶ್ಯಕತೆ ಇದ್ದಲ್ಲಿ ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸುವಂತೆ ಕೋರಲು ನಿರ್ದೇಶಿಸಿದ್ದೇನೆ.
ಅವಶ್ಯಕತೆ ಇದೆ, ಹಂಗಾಗಿ ಪ್ರಸ್ತಾವನೆ ಕಳಿಸಿದೀವಿ ಅಂತ ಹೇಳಿದಾರ ಇವರು?
ಇಲ್ಲ, ಐ ಓನ್ಲಿ ರಿಕ್ವೆಸ್ಟೆಡ್ ದಿಸ್ ಇಸ್ ದ ಲೆಟರ್ ರಿಟರ್ನ್, ದೇರ್ ಆಫ್ಟರ್ ನೋ ಆಕ್ಷನ್ ಇಸ್ ಟೇಕನ್.
ವಾಟ್ ಆಕ್ಷನ್? ಪ್ರೊವೈಡೆಡ್ ದೇ ಡಿಸೈಡ್. ಅವಶ್ಯಕತೆ ಇದೆ ಅನ್ಕೊಂಡು ಅನ್ಸ್ಬೇಕು ಅವ್ರಿಗೆ.
ಅದೇ ಅವಶ್ಯಕತೆ ಇದೆಯಾ ಇಲ್ವಾ ಅಂತ ಅಟ್ಲೀಸ್ಟ್ ಹೇಳಿ.
ಅದನ್ನ ಹೇಳಾಗ ಅವಶ್ಯಕತೆ ಇದ್ರೆ ನೀವು ತಿಳಿಸಿರಿ ಅಂತ ಹೇಳಿದಾರೆ.
Yes, my lords.
ಅವಶ್ಯಕತೆ ಇದೆಯೋ ಇಲ್ಲೋ ಅಂತ ತಿಳಿಸಿ ಅಂತ ಹೇಳಿಲ್ಲ.
Just before that, my lords, ಈ ಕುರಿತು ಸ್ಪಷ್ಟೀಕರಣ ನೀಡುವಂತೆ ಕೋರಲು ಹಾಗೂ ಸದರಿ ಪಟ್ಟಿಯನ್ನು ಪುನರ್ ಪರಿಶೀಲಿಸಿ ಪ್ರಕಟಿಸಲು ಕ್ರಮ ವಹಿಸುವಂತೆ. Please look at it. This is our clarification.
ಅಂತೆ ಮತ್ತು ಡಿವೈಎಸ್ಪಿ ಮುಂಬಡ್ತಿಯನ್ನು ಪುನರ್ ಪರಿಶೀಲಿಸುವ ಅವಶ್ಯಕತೆ ಇದ್ದಲ್ಲಿ ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸುವಂತೆ ಕೋರಲು ನಿರ್ದೇಶಕನಾಗಿದ್ದೇನೆ.
You review it. In case there is a necessity, then you please
ಕನ್ಸಿಡರ್ ಮಾಡ್ರಿ.
That's all that I'm doing.
So that consider that letter and whatever you want to do it with that letter.
One submission.
The only difficulty is
Tribunal will say, no, we are
settled
not
position
saying that
of
you accept it.
2015 seniority will
No,
be.
on that ground you reject it. ಇದನ್ನ ಇಟ್ಕೊಂಡು ಅವರು ಮತ್ತೆ ಮಿಸ್ಶಿಫ್ ಮಾಡ್ಬೋದು ಅಂತನಾ?
My lord, this matter has come for the first time, my lord. I will
Take note.
examine
Correct.
on how exactly the 2015 seniority list will be affected.
Yes.
One submission
Matter is
my lord,
allowed.
on a later.
Then I will make my
State
submission.
government writes to DGP.
Any
Both are my learned
but-
friends claim. So
Correct.
he possibly can't object to this saying that, no, I will not consider.
No, we do not know. That's an
I'm
internal
just-
communication.
Very well.
How it came to your hands?
My lords, that is because it is at my request. Would your lordships, my lords,
No,
kindly?
how it came to your hands?
Yes, my lords, because it is initiated at the instance of,
Initiated always.
Yes.
How it came to your hands?
my lords, because it is given to me, my lords.
Given to you.
Yes, my lord. I'll
Copies?
just, my lord, I'll verify that also and place it for your lordship's consideration on the next date, how my client, my lord, came in possession of that said document. My lord.
Petitioner to explain
Yes,
as to how the annexures
annexed
Nine
A10.
A9 and A10,
Yes,
copies of annexures A9 and A10 came to his hand,
yes,
his hands. And when? And when?
please.
First off, if plausible explanation is not given,
Yes,
that can be one of the grounds to deny justice.
please. Grateful.
Deny justice ತಗದು, to dismiss the petition. Petition. Learned AG issue notice, learned AG is requested to accept notice for respondents, call next week.
Please. Grateful.
Group matters number 32, Rangnath has right?
Lordship, this is regarding disciplinary inquiry.
ಹಾ,
Lordship, the
ರಂಗನಾಥ್ ಜೋಶ್ ಮೂವ್ ಮಾಡಿದ್ದಾರೆ, ಎಲ್ಲಿದ್ದಾರೆ?
Ashwini Haladi is a representative or Lokayita Lordship.
ಅಲ್ಲಿ ನೋಡಿ, ಅವ್ರ ಹೆಸರನ್ನು ತೆಗೆದು, ಕೂತ್ಕೊಂಡೆ ಬರ್ಕೊಳ್ಳಿ. Remove name of
PS Prasad.
and introduce name of, right name of BS Prasad, panel council. ಯಾರು ಮತ್ತೆ ಮೆಮೊ ಮೂವ್ ಮಾಡಿದವ್ರು ಯಾರು?
ಅವರ
ಪ್ರಸಾದೇ,
ಅಲ್ಲ ರಂಗ ಜೋಯಿಸ್ ಅವ್ರು ಮಾಡಿ
ರಂಗನಾಥ್ ಜೋಯ್ಸ್,
ಅವರು
ಪಾಸ್ ನೋಡ 4 ವರ್ಷ ಆಗಿದೆ ಆಲ್ರೆಡಿ.
ಅಲ್ಲ ಅಶ್ವಿನಿ ಹಾಲಡಿ ಅವರು ಇಲ್ಲ ಅಂತ ಹೇಳಿ
ಹಾ,
he is disabled
ನೆಕ್ಸ್ಟ್
because of that.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಆಫ್ಟರ್ ನೆಕ್ಸ್ಟ್
Please.
AGA for R1.
AGA for R1.
Number 33,
ಮುರಳೀಧರ್
Muralidhar KB.
KB.
Kindly pass over,
ಪಾಸ್ ಓವರ್,
please,
ಪಾಸ್. ಈಗಲೇ ಬರ್ಬೇಕು, ಮಧ್ಯಾಹ್ನ ಬೇರೆ ಬೆಂಚ್ ಇದೆ ಅದಕ್ಕೆ.
please.
ಇಲ್ಲ ಇಲ್ಲ ಇಷ್ಟೇ. ಓಕೆ. ಹಾ, ಬಿಡಮ್ಮ, ಕೂತ್ಕೊಳ್ಳಿ.
Number 32, 4, A Mahesh Chaudhary.
34.
For a pass over, I'm appearing for the petitioner
Huh.
in this matter, your lordship, seeking for a pass over, seniors on his legs.
Senior counsel will come. ಕರ್ಕೊಂಬರ್ರಿ, ಇವ್ರು ಬಂದಾರ. ಪಾಸ್ ಓವರ್.
Number 35. Same
Yes,
Nagapatna.
ಸರಿ ಏನಿಲ್ಲ.
It's a most unfortunate case, your lordship, because I reported to the KIDB, your lordship, on 22/12/2012.
What is the case about?
But the case is that this, your lordship, is they make a charge against me that I have paid the money for the second time for acquisition of the lands which were acquired earlier, your lordship. The question is, your lordship, on that basis, another co-employee against him also, inquiry was conducted by KADB. If I read only 3 lines in that inquiry, your lordship. Page 60.
During what period you were there in the KIDB? From which place, point to which point?
I came to KADB on 22/12/2012.
22/12/2012. And you were there till?
Acquisition was on 25, PN was issued on 25/10/2006. PN, your.
Preliminary notification.
Yes, your.
Preliminary notification is dated
25/10/2006, your lords.
25/8.
10,
10. 2006.
FN was issued on 29/10/2010.
Award was passed on?
10/8/2012, price advising committee fixes the price of 38 lakhs per acre.
Award was passed on, the advisory committee was there.
Yes, sir, 10/8/2012, your lords. Therefore, your lordship, everything was over, check was ready, I was handed over the check only to the person, your lordship. Issuing of a PN and final notification, how a responsibility can be fixed on me? That is because earlier, your lordship, the very same lands have been acquired for the water resource and Department of Irrigation Department on 11/12/1980. All this happened, your lordship, because as if I read only 5 lines of your lordship. Page 69, I read, your lord. From the 3rd line, I read, your lord.
Due to
non-performance of official duty being a public servant, that is authorities of irrigation department who acquired a subject land for construction of a channel or public product. The then Assistant Commissioner and SLO, as mentioned in Exhibit P1, revenue authorities such as the Tahsildar of Kanakpura Taluk, including subordinate such as the revenue inspector, are mainly responsible as they have failed in their duty as mentioned in para number 13.
What is this document you are reading?
Inquiry report.
Report itself.
Yes. On the same charge, similar charge. The retired district judge has done it, your lord.
This against you.
One of the accused.
There were other delinquents also.
Yes, one is Chandraju anta. On mele district judge appoint ಮಾಡ್ತಾರೆ. This is the.
Yes, brother, what do you say?
My lord, the charge sheet is at A11, my lord. It is only issued against this person, Amaresh, the petitioner.
He came to KDB on 22/12/2012.
Please, no.
Preliminary notification is 25/10/2006. Final notification October 2010. Award is August 2012.
Please.
Check was kept ready. By the time he assumed office, he took that check and gave it to the concerned. Where is the fault with him? Why? What action you have taken against those who did not mention that this acquisition is already done? It is second acquisition, fraud on the government. What action you have taken?
My lord, on that I had sent a letter, my lord. The earlier acquisition was in the year 1980 and 1987, my lord.
Correct.
And because this relates to a very long period ago, my lord.
No, why they did not mention it in the land revenue records?
Yes, my lord. That is specifically my query, my lord. They're still trying to ascertain why nothing was done, my lord.
No, this is
My lord,
fraud on the government. And what is his mistake?
And what I have done, your lordship, I have initiated.
my lord, from the inquiry,
Recover the money from them.
my lord,
Oh, recovered the money?
Yes, your lordship, by filing.
Yes, he has recovered the money also.
no, he is. I think he has made an attempt to recover by
Not
filing an
recovered.
OS, not yet recovered.
No, that not at.
And what is this?
Your charge
RFA
is not recovered. That
No,
is
my
not
lord,
his charge.
RFA was filed by the landowners, 50% was directed to be deposited, they have deposited, and I was told another 50% is also paid by them.
Paid means deposited.
Yes, your lordship.
No,
RFA
difference is there.
Yes, your
First,
lordship.
you are using English language very lavishly. Is it recovered or is it deposited in the court?
Page 181, I will bring to your lordship. 181, this is a letter of the government itself, your lordship.
181.
One. Second para I read you lords. ಪ್ರಸ್ತುತ
ಪ್ರಸ್ತುತ.
ಸದರಿ ಪ್ರಕರಣದಲ್ಲಿ ಈಗಾಗಲೇ 2 ಬಾರಿ ಭೂ ಪರಿವಾರ ಪಡೆದ ಭೂಮಾಲೀಕರಿಂದ 50% ಮೊತ್ತವನ್ನು ವಸೂಲಾತಿ ಮಾಡಲು ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಆದೇಶಿರುವುದರಿಂದ ಹಾಗೂ ಸಾರ್ವಜನಿಕ ಲೆಕ್ಕಪತ್ರ ಸಮಿತಿಯು ಸಭೆ ದಿನಾಂಕ 14/3/2020 ನೀಡಿರುವ ನಿರ್ದೇಶನದಂತೆ ಮತ್ತು ಶ್ರೀ ಅಮರೇಶ್ವರ ಹಿಂದೆಯೇ OS ರಿಕವರಿ ದಾಖಲೆ ಮಾಡಿ ವಸೂಲಾತಿಗೆ ಕ್ರಮ ಕೈಗೊಂಡಿರುವ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸದರಿ ಅಧಿಕಾರಿ ವಿರುದ್ಧ ಕ್ರಮ ತೆಗೆದುಕೊಳ್ಳುವ ಅವಶ್ಯಕತೆ ಇಲ್ಲದ ಕಾರಣ ಇಲಾಖೆಯು ನೀಡಿದ ಅನುಬಂಧ 1 ರಿಂದ 4 ದೋಷಾಪರಣ ಪಟ್ಟಿಯನ್ನು ಹಿಂದಿರಿಸುವಂತೆ ಈ ಮೂಲಕ ಕೋರಿದೆ.
ಏನ್ ಹಂಗಂದ್ರೆ?
ಅಂದ್ರೆ ಚಾರ್ಜ್ ಶೀಟ್ ನಮ್ಗೆ ಅಲ್ಲಿ ಮಾಡು ಅಂತ ಹೇಳಿದ್ರಲ್ಲ, ದಟ್ ಶುಡ್ ಬಿ ಗಿವನ್ ಬ್ಯಾಕ್ ಅಂತ ಗೌರ್ಮೆಂಟ್ ಅವರೇ ಹೇಳ್ತಿರೋದು.
ನಿಮ್ ಮೇಲೆ?
ಹೌದು, ಬಿಕಾಸ್ ದಿ ಮನಿ ಹ್ಯಾಸ್ ಆಲ್ರೆಡಿ ರಿಕವರ್ಡ್.
ಎಲ್ಲಿದೆ ಸೂಟ್? ಡಿಕ್ರಿಯಾಗಿ ಅಮೌಂಟ್ ಬಂದಿದೆ ಅಂತ ತೋರಿಸಿ.
ನಾನು ಡಿಗ್ರಿ ಓದ್ತೀನಿ ಸ್ವಾಮಿ.
ಡಿಕ್ರಿ ಆಗಿದೆಯಾ?
ಹೌದು,
ಎಕ್ಸಿಕ್ಯೂಟ್ ಆಗಿದೆಯಾ ಡಿಕ್ರಿ?
ಡಿಗ್ರಿ ಆಗಿದೆ. RFF ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ.
ಅವ್ರು ಮಾಡಿದ್ದಾರೆ.
ಹೌದು.
ಆ ಅಮೌಂಟ್ ಬಂದಿದೆಯಾ ಈಗ?
ಅದರಲ್ಲಿ 50% ಇದು ನಾನು ಲೆಟರ್ ಓದಿದ್ನಲ್ಲ ಗೌರ್ಮೆಂಟ್ 50. ದಿಸ್ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಡೈರೆಕ್ಟೆಡ್ ದಿ ಓನರ್ಸ್ ಟು ಡಿಪಾಸಿಟ್ 50% ಇನ್ ದಿ RFA.
ಅವ್ರು ಡೆಪಾಸಿಟ್ ಮಾಡಿದಾರ ಈಗ?
ಮಾಡಿದ್ದಾರೆ.
ಇನ್ನು ರಿಮೈನಿಂಗ್ 50%?
ಇಟ್ ಇಸ್ ಎ ಪೆಂಡಿಂಗ್
RFA ಪೆಂಡಿಂಗ್ ಇದೆ.
ಪೆಂಡಿಂಗ್.
Because undertaking is given by the land losers at the time of receiving the compensation that they will return the
The thieves have returned the money. So the theft has come to an end.
My lord, may I just clarify one point, my lord. The information I've received from the department is also quite vague. They don't seem to be making proper efforts to give me information. I've been following up since the matter was listed day before yesterday, my lord. What they've told me is this.
What action you have
specifically the allegation in the charge sheet. I'll begin from
Come to that
Just-
one. What action you have taken
Yes,
against
I'll come to
those fraudulent revenue officials
Please.
who did not make entry of the award of acquisition?
I'll
in the
answer.
revenue records.
Please, I'll answer the question. My lord, in the articles of charge, the allegation is that he paid compensation to land losers who had already received compensation in respect of the same lands which were acquired in 1980 and 87.
Correct.
Now, the misconduct essentially is that he issued the check without verifying the RTC records. However, the RTC records did not,
That's what.
the changes were not affected subsequent to the
How he
acquisition.
will know land is
My lord,
I am asking.
My lord, what I've been told is there has been an entry. This is what I've been told. This is a vague information I've received, my lord. I've been trying to follow up with them. They are saying there is an entry made in the RTC, but it is not made in the relevant column. At somewhere at
Says, who should have made that entry?
the concerned revenue officials.
ಅವ್ರ ಮೇಲೆ ಏನ್ ಆಕ್ಷನ್
My
ತಗೊಂಡಿಲ್ಲ?
lord, ಅವ್ರ ಮೇಲೆ ಏನು ತಗೊಂಡಿದ್ದಾರೆ ಇಲ್ಲ ಅನ್ನೋದಕ್ಕೆ ಕ್ಲಾರಿಟಿ ಬಂದಿಲ್ಲ.
ಅದನ್ನ ಹೇಳ್ಬೇಕು. ಹಂಗೆ ತಗೊಂಡೆಲ್ಲ
And
ತಿಂದು
that is the
ಹೋಗ್ಬಿಟ್ರೆ
query in my
public
letter also.
money ಒಂದೊಂದು ಲ್ಯಾಂಡಿಗೆ 3 ಸರಿ acquisition ಆಗಿದೆ.
Please.
ಇಲ್ಲಿ 2 ಸರಿ ಆಗಿದೆ. Other matters we are dealing was thrice it has been done. Thrice payment is made and still they are continuing in occupation.
My lord, something more than what meets the eye is
Ah,
going on and I'm not
ಎಲ್ಲ
getting
ಹೀಗಾದ್ರೆ ಹಂಗೆ. Therefore,
information in this
separate
matter.
bench, we treated 1 lakh odd acres of land. We got all the entries mutated in favor of Karnataka Niravari Nigama, myself and Erur Saab. What action you have taken against that? You are barking at, this is a dog barking at the wrong tree.
My lord, that is the specific query. They have not come up with a proper explanation to me. I've been following up with them through email, through letter and through WhatsApp.
ಯಾರು
messages.
concerned, ಯಾರು ನಿಮ್ಗೆ?
My lord, the officers of the DPR as well as the
ಯಾರು?
C&I are present. my lord.
ಕರೀರಿ ಅವರು. ಯಾರು DPR ಯಾರು ಇದಾರ ಅಥವಾ ವಾರಂಟ್ ಕೊಡ್ಬೇಕಾಗತ್ತಾ? Generally, we will not call officers because of 2024 judgment. But there are 3 exceptions indicated by the apex court. This case falls within one of them, 2 of them. ಅವರಿಗೆ ಮಧ್ಯಾಹ್ನ ಇರ್ಲಿಕ್ಕೆ ಹೇಳಿ.
Please.
ಯಾಕೆ ಕೊಡ್ತಾ ಇಲ್ಲ information? What action they have taken? We will make an order now so that it becomes handy to you.
Please.
Okay? ಬರ್ಕೊಳ್ಳಿ. There is absolutely nothing. He has done more than what he was required to do. What is this? You are doing this. ಬರ್ಕೊಳ್ಳಿ. The charge against the petitioner was that he had made double payment in respect of acquisition of subject land, in the sense that already land was acquired way back in 1980s.
And 87. 80 and 87 is.
80, 81.
80, 87, my lord. 80 and 87 is what is mentioned in the articles of charge.
Yes. in 1987, and compensation was paid. First, learned counsel for the petitioner notifies to us that he became SLAO, na?
SLO.
He assumed charge of SLAO in the KADB only on 12/12/2012. And by that time, already award was passed on 10/8/2012. 7. He had only handed the check of award amount. And that after coming to know of the double payment, he instituted the OS number.
OS number OS number 635 of 2014.
635 2014, decreed on.
It was decreed on 20th December 2018, my lord.
Decreed on 28/12/2018 against the recipients of second award amount. First, he also tells us that these recipients have filed RFA number
677 of 2019, my lord.
677 of 2019, wherein there is a stay of decree subject to depositing 50% of the decretal sum. And that is already deposited. First, next paragraph. Apparently and arguably, there is no culpability attributable to the petitioner. First, that needs deeper examination. Next. In the meanwhile, those of the very same land and payment of compensation, therefore, have not been put to accountability. First off, the second acquisition apparently happened because the first acquisition award was not reflected in the revenue records. First off, therefore, court wants to know. When ನಾವು ಹೇಳೋಣ ಅವರು ನಿಮಗೆ ಫರ್ನಿಶ್ ಮಾಡ್ತಾ ಇಲ್ಲ, ಕೋಆಪರೇಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ ಅಂತ ಬರೀಬೇಕೋ ಅಥವಾ ಅವರು ಸುಮ್ಮನೆ ಸ್ವಲ್ಪ ಗೌರವಯುತವಾಗಿ ಅದನ್ನ ಕೊಡ್ತಾರೋ? ಗೌರವಯುತವಾಗಿ ಕೊಡಂಗಿದ್ರೆ ಒಳ್ಳೇದು, ಗೌರವಯುತವಾಗಿ ನಡೆಸ್ಕೊಳ್ತೀವಿ. ಇಲ್ಲ ಅಂದ್ರೆ ಬೇರೆ ಮಾಡ್ಬೇಕಾಗ್ತದೆ. ಎರಡೆರಡು ಸಾರಿ ದುಡ್ಡು ಕೊಟ್ರೆ ಕೋಟಿಗಟ್ಲೆ ಯಾರ್ದದು ಅಮೌಂಟ್?
He is expressing his difficulty, saying that it is the revenue department which has to answer this question.
Ask revenue. ಯಾರು ನೀವು ಕೇಳ್ಬೇಕಿತ್ತು ರೆವೆನ್ಯೂ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ನಿಂದ. ನೀವು ಗವರ್ಮೆಂಟ್ ನೀವು ಏನ್ ಮಾಡಿದ್ರಿ? ಇವು ಇನ್ನೋಸೆಂಟ್ ನ ಹರಾಸ್ ಮಾಡಿ ಯಾರು ಅದನ್ನೆಲ್ಲ ತಿಂದು ಹೋಗ್ಬಿಟ್ಟಾರೆ, ಅವ್ರನ್ನ ಯಾಕೆ ಬಿಟ್ರಿ?
In fact, I have found out, my lord, that Tahsildar is required to inform the special land acquisition officer whether he should release the money or not, having verified the records. This is what I found out from inquiring on the
We are just
how this
asking.
process is conducted, my lord.
Award is not reflected in the revenue records. Where award is passed, Justice Mirde said, the revenue authority should make the entries, mutate the entries in the revenue records. Otherwise, the same person, the land will be acquired multiple times, so that continuously it will generate income to the persons who are no longer the owners.
In fact, it was brought to the attention of the authorities by one of the brothers, I feel, relatives of the person who received the compensation, my lord. Seeing
Anyway,
that
at least
they
he has
received
made efforts,
compensation.
ಡಿಗ್ರಿ ಮಾಡ್ಕೊಂಡಾನೆ. ಆಮೇಲೆ ಇಲ್ಲಿ RFA ದಲ್ಲಿ 50% ಅಮೌಂಟ್ ಡೆಪಾಸಿಟ್ ಆಗಿದೆ. RFA ಡಿವಿಷನ್ ಬೆಂಚ್ ಮುಂದಿದೆಯಾ ಸಿಂಗಲ್?
Division bench, my lord.
ಬರ್ಕೊಳ್ಳಿ. We'll call that matter.
My lord, if a direction is given to the revenue authorities to give this information, my lord, because I'm told that he will require their cooperation. which will
Revenue
be-
authority. What you are going to, we do not know. Otherwise, we will direct some suspension of concerned person now, direct ಮಾಡ್ತೇವೆ. ಅವ್ರು ಏನು ಅದೆಲ್ಲ ಇನ್ಫಾರ್ಮೇಶನ್ ತಂದು ಕೊಡ್ತಾರೋ ಕೋರ್ಟಿಗೆ ಇಲ್ಲ ಕೇಳಿ. ಹೆಸರು ಹೇಳಿ. ಹೆಸರು ಹೇಳಿ.
Please, ma'am, I'll write it.
ಇಲ್ಲಿ ಬನ್ನಿ, ಈ ಕಡೆ ಬಂದ್ಕೊಂಡು ಮಾತಾಡಿ, ರೆಕಾರ್ಡ್ ಆಗ್ಲಿ ಅವ್ರ ವಾಯ್ಸ್. ಬನ್ನಿ ಬನ್ನಿ. ವಾಟ್ಸ್ ಯುವರ್ ನೇಮ್? Please come here. What is your name? What is your designation? How long you have been working in KIDB?
Lords, I'm the legal advisor for C&I department,
Legal advisor to?
Commerce and Industries department.
Is it, do you hold a civil post or you are just an advocate?
I'm just a legal advisor over there, my lord.
Do you hold
Contract
civil
basis.
post?
On a contract basis.
On contract basis. ಮತ್ತೆ ಏನಾರ ಮಾಡ್ಬೇಕಲ್ಲ ಇದರಲ್ಲಿ?
Definitely, my lord.
ಏನ್
We'll
ಮಾಡ್ತೀವಿ?
coordinate, we'll get the information before the court, my lords.
The legal advisor of, advisor, Mr.
Rishabh.
Rushank, of, our department,
Commerce and Industries department.
Commerce and Industries Department, personally present before the court, submits that the department would interact with the coordinate departments, namely Revenue Department, and procure the details of all officials who are responsible for not making entries in the revenue records, which eventually resulted into land being acquired second time. First off, this court suspects some scam-like thing in these, in as much as many such matters are coming before this court. First off, the principal secretary, Revenue Department, on being handed this letter, shall initiate and accomplish appropriate action against the erring officials and report it to this court within 2 weeks. 2 weeks. First off, non-compliance may result into he being summoned to answer the explanation, offer the explanation.
But the presence of the DPR officials may also be, the charge, articles of charge is issued by them.
DPR.
DPR.
DPR ಆಲ್ ರೈಟ್, ಅವ್ರು ನೋಡೋಣಂತೆ. ಈಗ ಇವ್ರು ನಿಮ್ಮ ರೆವೆನ್ಯೂದವ್ರು ಇದನ್ನ ಮಾಡಿದ್ರೆ ಈ ಪ್ರಾಬ್ಲಮ್ ಬರ್ತಿರ್ಲಿಲ್ಲ. ಬರ್ಕೊಳ್ಳಿ. Registry to explore the possibility of the feasibility of posting the RFA and this WP together before one bench, one of the benches.
Before your lordship.
ನಾವ್ ಹೆಂಗ್ ಕಳ್ತೀವಿ, ನಮ್ಮ ಅವ್ರ ಪ್ರೊರಗೇಟಿವ್. ನೀವು ಬೇಡ ಇನ್ನೊಬ್ಬರಿಗೆ ಕೊಡ್ತೀವಿ ಅಂತ ಚೀಫ್ ಜಸ್ಟಿಸ್ ಹೇಳ್ಬೋದು. ನೋಡ ನಾವು ಹಂಗೆ ಬರೋದು. One of the benches, after seeking appropriate orders at the hands of Honorable the Chief Justice. Okay.
32.
ಹೊಲ್ರಿ ಬಂದಾರೆ, ರಾಜಗೋಪಾಲ್ ಇದ್ದಾರೆ, ಕರಿ. ಏನ್ ಹೆಂಗಾಗ್ತಾ ಇದೆ ಅಂತಂದ್ರೆ ಹೊಳ್ರೆ ಮತ್ತು ರಾಜಗೋಪಾಲ್ರೇ, ಅದು ಪ್ರೊಫೆಸರ್ ಒಂದೇ ಲ್ಯಾಂಡು
ಗೊತ್ತಾಯ್ತು 2 ಸರಿ
5 ಸರಿ ಎಕ್ವೈರ್ ಆಗಿದೆ ಧಾರವಾಡ. 5 ಸಾರಿ ಸೇಮ್ ಲ್ಯಾಂಡ್ ಈಸ್ ಎಕ್ವೈರ್ಡ್ 5 times. 5 times ಮನಿ ಈಸ್ ಪೇಡ್. ನಾವು ಜಸ್ಟ್ ಹಂಗ ಟರ್ನ್ ಮಾಡಿದಾಗ ಸೇಮ್ ಲ್ಯಾಂಡ್ 5 ಸಾರಿ ದುಡ್ಡು ಕೊಟ್ಟಾರೆ, ಕೋಟಿ ಗಟ್ಲೆ. ಹೆಂಗೆ ಪತಿ ಎಲ್ಲ ಜನರ ಮೇಲೆ ಜನ ನಾವು ಕೊಡೋದು ಕೆಲ.
ಗೊತ್ತಾಯ್ತು, ಎಲ್ಲ ನಾವು ನೀವು ನಮ್ ಟ್ಯಾಕ್ಸ್ ಪೇಯರ್ಸ್
ಕೊಡೋದು. ಯಾಕೆ ಅಂದ್ರೆ ಸಣ್ಣ ಮಿಸ್ಟೇಕ್ ಇಂದ ಏನು ರೆವೆನ್ಯೂ ರೆಕಾರ್ಡ್ಸ್ ನಲ್ಲಿ ಚೇಂಜ್ ಆಫ್ ಎಂಟ್ರಿ ಇದೆ ಅಲ್ಲ, ಅದನ್ನ ಕರೆಕ್ಟ್ ಚೇಂಜ್ ಆಫ್ ಎಂಟ್ರೀಸ್ ಮಾಡ್ಲಿದ್ರೆ ಅವ್ರಿಗೆ 25 ವರ್ಷ ಕಠಿಣ ಶಿಕ್ಷೆ ಅಂತ ಮಾಡಿದ್ರೆ ಇವೆಲ್ಲ ಆಗಲ್ಲ. ಚೇಂಜ್ ಆಫ್ ಎಂಟ್ರಿ ದೇ ಥಿಂಕ್ ದಟ್ ಇಟ್ ಈಸ್ ಎ ಸ್ಮಾಲ್ ಥಿಂಗ್ ಅಂಡ್ ಎಂಟ್ರೀಸ್ ವಿಲ್ ನಾಟ್ ಗಿವ್ ಟೈಟಲ್ ಟು ದಿ ಪ್ರಾಪರ್ಟಿ ಅನ್ಕೊಂಡು ನಾವು ಹೋಲ್ಡ್ ಮಾಡ್ಕೊತ ಬಂದ್ಬಿಟ್ಟಿವಿ. ಹಂಗಿರಲ್ಲ. ಲಾಟ್ ಮೆನಿ ಕಾನ್ಸಿಕ್ವೆನ್ಸಸ್ ಫಾಲೋ ಬಿಕಾಸ್ ಆಫ್ ದ ಎಂಟ್ರೀಸ್.
ಅಲ್ಲ ಇದ್ರಲ್ಲೇ ನೋಡ್ತಿರಲ್ಲ, ಇದ್ರಲ್ಲೇ ನೋಡಿದ್ರಲ್ಲ 5 ಜನಕ್ಕೆ 5 ಸತಿ ಪೊಸಿಷನ್
5 ಸರಿಯಾಗಿ ಎಕ್ವಿಜಿಷನ್
ಪೇಮೆಂಟ್ ಆಫ್ ಕಾಂಪನ್ಸೇಷನ್.
ಆಮೇಲೆ ಪಾಪ ಅವ್ರ ಕ್ಲೈಂಟ್ he has taken we have filed suit for recovery also. ಯಾ ನಮ್ನಿ ಆಗಿದೆ ಅವನ ಮೇಲೆ ಆಕ್ಷನ್.
It is like not such, it is like punishing the officer who detected the fraud.
Correct. ಇದು the victim has to apologize to the attacker. ಹಂಗಿದೆ.
The banks ಅಲ್ಲಿ ಒಂದು ರೂಲ್ ಇದೆ, every time key changes the hands, we have to check the entire contents of the strong room. It is impossible.
Is it possible?
One manager, poor man, he took charge. Then he told, I have not, he thought, I have not surprise checked for 3 months. Today, anyhow, I am in charge of it. I will check. When he checked, he found 26 gold jewels missing. ಕಡೆಗೆ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿ ಅವ್ರಿಗೆ ಕ್ರಿಮಿನಲ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಅವ್ರಿಗೆ ಡಿಪಾರ್ಟ್ಮೆಂಟಲ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್
ಭಾಳ ಡಿಫಿಕಲ್ಟ್ ಇದೆ. ಇದಕ್ಕೂ ಎಷ್ಟು ಸಿಂಪಲ್ ಇದೆ. ಏನು ಮೆನಿ ಥಿಂಗ್ಸ್ ವಿ ಆರ್ ಸೀಯಿಂಗ್ ನಾವು. ಐ ಆಮ್ ಮೆನಿ ಥಿಂಗ್ಸ್ ಅನ್ಫಾರ್ಚುನೇಟ್ಲಿ ದೇರ್ ಇಸ್ ನೋ ಇಂಟರ್ಫಿಯರೆನ್ಸ್ ಫ್ರಮ್ ಎನಿಬಡಿ. ಐ ವಾಸ್ ಜಸ್ಟ್ ವೇಟಿಂಗ್ ಸಂಬಡಿ ಇಂಟರ್ಫಿಯರ್ಸ್ ಅಂತ. ಯಾರು ಬರ್ತಾ ಇಲ್ಲ. ಹಂಗೆ ಹಿಂದಿಂದ ದೂರದಿಂದ ಹೆದರಿಸ್ತಾರೆ ನಾನು, ಅಷ್ಟು ಬಿಟ್ರೆ ಹತ್ರ ಬರ್ತಾ ಇಲ್ಲ ಅವರು ಯಾರು.
Sir, what happened is this, in main.
ಹೇಗೆ ಬೇಕಾದ್ರು IA, my lord, we have filed the IA. If your lordships are disposed in the main matter also, I have no problem. Only thing is.
Because.
ಮೇನ್ ಇದ್ರಾಗೆಲ್ಲ ಅಯ್ಯಪ್ಪಯ್ಯ ಬರಲ್ಲ ಇದು. ಮೇನ್ ಮ್ಯಾಟ್ರೆ ಆರ್ಗ್ಯೂ ಮಾಡಿ
Please.
No, my lord, the petitioner is a Tahsildar,
ತಹಶೀಲ್ದಾರ್.
grade 1.
ಏನ್ ಟ್ರಾನ್ಸ್ಫರ್ ಮ್ಯಾಟ್ರ್ ಇದು?
I passed on, sorry, my lord, sir, whatever, I should not say it. 12th matter ನಡೀತಾ ಇದೆ ಅಂತ I went to walk up to the end of the second.
No,
and
we
come
know,
back.
we will never, we
That
know
is
which
the-
matter. How, what
I saw
advocates
the
are.
court thing, but I could not run my.
No,
lord.
you need not run at all.
Yes, no, sir.
Or if you want, we take this matter some other day, we'll take some other day.
ಇಲ್ಲ, ಇಲ್ಲ,
2025.
I-
We know which advocates, ಅವರೆಲ್ಲ ನೀವು 10 ಸರಿ ಬರಲಿದ್ರು we understand. Without reason, you will not stay away at all. ಈಗ ಹೊರಡ್ರು 10 ಕಡೆ
ನಾನು ಬರೋ
ಇರ್ತಾರೆ.
ಅಷ್ಟೊತ್ತಿಗೆ ಹೊರಡ್ರು, he was just.
ಅವ್ರ ಜೊತೆ ನಿಮ್ಗೆ ಓಡಕ್ ಆಗಲ್ಲ, ಯಾರಿಗೂ ಆಗಲ್ಲ ಅವ್ರ ಜೊತೆ ಓಡೋದು.
ಅವ್ರ
ಈಸ್ PT ಉಷಾ ಆಫ್ ಅವರ್ ಕೋರ್ಟ್. ಒಂದ್ ಕಡೆ ಇಲ್ಲಿರ್ತಾರೆ, 2ನೇ ನಿಮಿಷಕ್ಕೆ ಅಲ್ಲಿರ್ತಾರೆ ಅವರು. Anyway,
ನಮ್ಮ ನೋಡ್ಸ by.
ಏನ್ ಇಶ್ಯೂ? ಕಮ್ ಟು ದಿ ಕ್ರಕ್ಸ್ ಆಫ್
This is Tahsildar was transferred within 3 months of his 4 months of his reporting for duties. Then, my lords, that was questioned. That reason behind that is in the Akrama Sakrama Samiti, of which the Tahsildar is the member secretary. MLA wanted certain things to be done which were contrary to law. When that was not done, my then, my lords, on 31st of December 2024, he was transferred out to another place, and on the basis of the letter of that MLA with whom all this had happened. Thereafter, one person who was posted in charge was a person who was already working at that particular place, and against whom investigation in respect of certain irregularities there at the hands of the Lokayukta are going on. That order I questioned before the tribunal. Principally, my lords, on 3 grounds. One is it is premature. Then, my lords,
malified.
One is premature. Within exactly 4 months, I have been shifted. Second is, my lords, it is after the transfer period, because transfer period ended on 31st of July 2014, 24. And at the last day of the transfer season, I was transferred there. With then 1st August I reported, 31st is matter, premature, it is outside then. Third, my lords, under the new transfer policy that has come, there are 5 circumstances under which a out of season transfer can take place. My case does not fit into any one of them. I was granted stay, and pursuant to stay order, I continue. Then, my lords, my application has been dismissed by the tribunal on 2 grounds. First ground it says is that Tahsildar, the chief minister has approved. My response submission is in the transfer policy presently there, the premature transfer cannot be done except where it falls under any one of the grounds under para 7 of the transfer season.
In other words, para 7 coupled with chief minister's.
The para 7 ಅಲ್ಲಿ ಏನಾಗಿದೆ, ಕಾಂಪಿಟೆಂಟ್ ಅಥಾರಿಟಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಚೀಫ್ ಮಿನಿಸ್ಟರ್ ಅನ್ನೋದು ಎಲ್ಲೂ ಯೂಸ್ ಮಾಡಿಲ್ಲ. And it can be only under those five circumstances, I do not fit into that. Second is, my lords, there is a complaint against me and another reason given. That complaint was, my lords, on 22nd of August. I reported there for duties on 1st of August. On 22nd of August, Deputy Commissioner comes to the office at about 11 o'clock and he finds I am not in office. He issued me a show cause notice. Then immediately I replied saying that I had to meet Assistant Commissioner in respect of a pending file. Along with that, from 10:20, I was in the office of the Assistant Commissioner along with the file and reply madadru. Thereafter, no action has been taken. And under the transfer policy, unless charge sheet is issued, that is disciplinary proceedings are pending, in contemplation of disciplinary proceedings, they cannot transfer. Here, there is neither anything pending nor contemplated. Pendency of the charge sheet, you cannot issue, you cannot transfer. These are the grounds I raise. Now, the two grounds that the tribunal says is, if my lords would kindly say, take my lords, the order of the tribunal. It is at page 20. The reasoning, my lords, is at page 29 onwards.
On perusal of submissions.
On perusal of submissions made by the learned counsel for the applicant has submitted his explanation to the said show cause notice. However, one S.N. Narayan Swami KM, MLA of Bangarpet Taluk, also written a letter to the Revenue Minister for transfer of the applicant who remained absent in the office, etc., which could be seen from Annexure R2 letter. The Honorable Chief Minister has given a note to the Principal Secretary to Government Department, Revenue Department on 13/12/2024, stating that fourth respondent is to be posted in the place of the applicant for the administrative reasons. Subsequently, impugned transfer order has been passed based on the note of the Honorable Chief Minister. The facts make it clear that even though the applicant transfer is premature, it has been issued after prior approval of the Honorable Chief Minister based on certain allegations made against the applicant. Under such circumstances, I hold that the impugned transfer order has been issued in compliance with clause 5.3 of the transfer guidelines referred to Supram, and pursuant to the transfer order dated 31/12/2024, the private respondent has been relieved from his arrear place and she has reported for duty at the transfer place on 31/12/2024 itself, which could be seen from Annexure R5 and
File kodi. What Justice Ramesh Bench said, how the Chief Minister should write the approval, which is that judgment, division bench.
Rajshekhar. M. Rajshekhar.
Yes, where is that judgment?
The citation is there. M. Rajshekhar.
It says that the proposal is to emanate from the authority, from the department. Then, my lords, it goes for the approval of the minister, my lords. And
No,
the
it
chief
appears there
minister.
is one judgment which says,
Rajshekhar.
Chief Minister has to assign reasons as to why he is approving.
That is a requirement of the policy.
No.
M. Rajshekhar.
Not that,
versus
the proposal has to go with the reasons. And if the proposal is approved with reasons, now in this
That
case, my lords,
becomes the reason.
please, my lords, in this case, what has happened is, if my lord, I have put two flags, my lords. First one, the tippani anta, on the CM tippani anta, second flag is on. This was a tippani that came, my lords, from the CM's office, my lords, prior to the transfer order. Based on the request, my lords, of the jurisdiction of the MLA. Both these tippani, my lords, and the request have been read into the file note and the notings have started, my lords, from page 1. Thereafter, my lords, again it goes to the Honorable Chief Minister and again it is approved. Note 1 in the start ಆಗುತ್ತೆ sir. ಅಲ್ಲಿ read ಮಾಡ್ತಾರೆ. Note first note.
Note 1.
Note 1. ಅಲ್ಲಿಂದ read ಆಗುತ್ತೆ. ಅಲ್ಲಿಂದ ಟಿಪ್ಪಣಿ ಮತ್ತೆಲ್ಲ read ಆಗುತ್ತೆ ಮತ್ತೆ.
ಕೊಡಿ ಕೇಳಿದೇನೋ ಇರುತ್ತೆ. ILR ರಿಪೋರ್ಟ್ ಆಗಿದ್ದೀರಾ?
Give that judgment, Mr. Rajgopal,
2019, 2019, volume 2, KLJ, page 352. I have a soft copy only. I have.
He has offered explanation that he went on official work to Assistant Commissioner's office.
Sorry, minutes. Thereafter, my lords, the MLA again writes to the chief, to the concerned revenue minister.
When was he upset?
Please.
He refers in that letter only to this show cause notice. That letter I have produced.
ಅದು absence ಅನ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ, ಅದು ಡ್ಯೂಟಿ ಅದು.
Please. Oh, if my lords,
Even in the
in the
reply they
petition
have
itself,
filed
my lords,
before the tribunal, they refer to the very
But,
same show
page-
cause notice.
page 120.
Page 116 of the report.
ಸೂರಜ್ ಗೋವಿಂದರಾಜ್ ಅವ್ರ DB judgment ಎಲ್ಲಿದೆ?
That is
ಕೊಡಿ.
2000.
Latest judgment.
That is not so it binds ಅಂತ ಹೇಳಕ್ಕೆ. That is referred to in the judgment latest.
ಅಲ್ಲ, ಅಲಿಗೇಷನ್ ಮಾಡಿದಾಗ ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಬಂದ ಮೇಲೆ ಎನ್ಕ್ವೈರಿ ಇನಿಶಿಯೇಟ್ ಮಾಡಿದ್ರೆ ಮಾತ್ರ ಟ್ರಾನ್ಸ್ಫರ್
That is the
ಮಾಡಿ
exact wordings,
ಬರಲ್ಲ ಅಂತ
where the
ಮಾಡಿದ್ರು.
where the
that
disciplinary
judgment,
proceedings are initiated ಅಂತ.
ಬ್ರದರ್, ಸೂರಜ್ ಗೋವಿಂದರಾಜ್ ಸಾಹೇಬ್ರದ್ದು ಯಾವ್ದು ಜಜ್ಮೆಂಟ್, ಲೇಟೆಸ್ಟ್ ಜಜ್ಮೆಂಟ್ ಬಂತಲ್ಲ,
Merely on allegations.
ಯು ಕೆನಾಟ್ ಟ್ರಾನ್ಸ್ಫರ್ ಅಂದ್ಕೊಂಡು, ವಿಚ್ ಇಸ್ ದಟ್ ಜಜ್ಮೆಂಟ್? DB ಫಾರೆಸ್ಟ್ ವಿ ರೋಟ್ ದಟ್ ಜಜ್ಮೆಂಟ್ ನಾ, ಅವೆಲ್ಲ ನೋಟ್ಸ್ ಮಾಡ್ಕೋಬೇಕು. ನಾವೇ ಎಲ್ಲ ಹೇಳಂಗಿದ್ರೆ ಏನು ಉಪಯೋಗ? ನೀವು ನೋಟ್ಸ್ ಮಾಡ್ಕೋಬೇಕು. ಗೌರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ಗಳು ಅವ್ರು ಬಿಡಿ, ಅವ್ರ ಎತ್ತರ ಮಾಡ್ತಾರೆ, ಅದು ಮಾಡ್ಕೊಳ್ಳಿ. ನೀವು ಗೌರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ಸ್ ಎಲ್ಲ ನಾವು ಹೇಳೋ ಜಜ್ಮೆಂಟ್ಸ್ ನೋಟ್ಸ್ ಮಾಡ್ಕೊಂಡು, ಇಲ್ಲ ನಮ್ ನೋಟ್ಸ್ ತರ್ಕೋತ್ ಕೂತ್ಕೋಬೇಕು ನಾವು ಎಲ್ಲದು ಪ್ರತಿಯೊಂದಕ್ಕೂ.
That may be in conflict with Agarwal's judgment, my lord, of the apex court, where it is said that transfer can be considered as one of the alternatives to suspension. When
Correct, but that is not the case. Correct. That's
No, no,
but
even
that's not the case here.
and that has been incorporated in our transfer guidelines also.
Saying,
Instead of suspending an employee, you can transfer.
That is not there.
no, that is not your case.
That is not my case. That, my lords,
The rule provides that is another thing.
that is another.
But that rule is not operated.
That's 128, page 128 of the paper book. His is reply to the show cause notice. Kindly just see the timeline, my lords.
128.
128, Annexure E. So this is dated 24/8. This is in the 8th month, my lords. My lords have 128.
128.
128, my lords.
128.
Annexure E.
Mr. Where is the state government's reply?
ಇದು ಜೆರಾಕ್ಸ್ ಕಾಪಿ ಆಫ್ ದಿ ಒರಿಜಿನಲ್ ಫೈಲ್ ತಾನೆ?
ಹೌದು, ಇದು because it's a e-file, my lords. It is a printout and a
Print out.
printout copy.
Print out.
This was what was produced before the tribunal also.
Right.
So I've got the same.
ಹಾ.
My lord,
128 ನಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾ ಇದೆ?
128, my lords, this is dated 24/8/24, when he gives a reply to the show cause notice issued by the deputy commissioner.
ಹಾ.
And then, my lords, kindly see the letter on the basis of which, my lords, this proceeding started is at 120. If the reply to the show cause notice gets closed there.
120.
120. So this is, my lords, from the member of the local representative.
That is immediately after the
4 months after.
This is
not
forwarded
immediate.
to the revenue minister. Revenue minister forwards it to the chief minister. Chief minister puts up that note. Thereafter, again, the file, my lords, it is not that on the basis of that note itself, a transfer is made. Then, my lords, again, there is a file noting to say on the basis of the this letter and the chief minister's note, again, file is built up, my lords, with regard to the application of mine. Then it goes again to the concerned principal secretary, revenue minister. Then the chief minister again gives his approval. So in terms of the transfer guidelines, we have followed the procedure. My lords, in respect of other aspects of the matter, my lords may consider. I have the
My lords may
my lords, whenever I hand over the files to the courts, I always say, my lords, there is a maxim called res is loquitur, which is used as a maxim, my lords, in the law of negligence. The facts speak for themselves. I always say the record will speak for themselves. So I cannot add much into it, but I can certainly explain, my lords, how my lords, the things happened, my lords.
Yes, Mr. Holla.
My lord, MLA ಕೊಟ್ರೆ ಅದು ಆಗೋದಿಲ್ಲ ಅಂತ ಹೇಳಿ ಇಲ್ಲ. Please look at, my lord, one
He's representative of the people.
one judgment, my lord, of the Honorable Supreme Court.
He can always that one.
ಅದು ಏನಾಗಿದೆ, first time, my lord, the deputy commissioner went, he says, you are not in the, my lord, they are required to, my lord, stay in the very locality, my lord, in the in Bangarpet itself. He is not staying in Bangarpet. He says, my lord, I am coming from Bangalore. ಅಲ್ಲೂ ಹೇಳಿದರು ಅವರ.
No, he went to
ಇಲ್ಲ
jurisdictional office of
ಇಲ್ಲ
assistant
ಒಂದು ನಿಮಿಷ.
commissioner.
My lord, please have a look at, my lord, his explanation at page 128.
128.
ಹೌದು. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಉಲ್ಲೇಖಿತ ಸೋನ್ಸು ಆಮೇಲೆ ಪ್ಲೀಸ್ ಕಮ್ ಟು, my lord, 1, 2, 3, 4
last paragraph.
ಒಂದ್ ನಿಮಿಷ, ಲೆಟ್ ಮೀ ಸೇ ಇಟ್ ಇನ್ ಮೈ ಓನ್. ನಿಮ್ಮ ಲಾಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಗಿಂತ ಮುಂಚೆ ಮೇಲಿನ ಪ್ಯಾರಾಗ್ರಾಫ್ ಓದ್ಬೇಕಾಗುತ್ತೆ. ಕಚೇರಿಗೆ ಹಾಜರಾಗದೆ ಸಮಯ, my lord, 1, 2, 3, 4, 5, 6 lines from the in the first paragraph. ಸಹ ಕಚೇರಿಗೆ ಸರ್ಕಾರಿ
ತಹಶೀಲ್ದಾರದ ನೀವು ಕೇಂದ್ರ ಸ್ಥಾನದಲ್ಲಿ ವಾಸವಿರದೆ ಹಾಗೂ ಸಾರ್ವಜನಿಕರಿಗೆ ಲಭ್ಯವಿರದೆ ಪ್ರತಿದಿನ ಬೆಂಗಳೂರಿನಿಂದ ಪ್ರಯಾಣಿಸುತ್ತಿರುವುದು ತಿಳಿದು ಬಂದಿರುತ್ತದೆ.
ಈಗಾಗಲೇ ಸರ್ಕಾರದಿಂದ ನಿಗದಿಪಡಿಸಿರುವ ಹಲವು ಯೋಜನೆಗಳಂತ ಸೋನ್ಸು ಬಗರ್ ಹುಕುಂ ಇಂಥ ಕೆಲಸಗಳಲ್ಲಿ ಪ್ರಗತಿ ಸಾಧಿಸುವ ಅವಶ್ಯಕತೆ ಇರುವುದರಿಂದ ಯಾವುದೇ ಬಗ್ಗೆ ಮೇಲ್ವಿಚಾರಣೆ ಮಾಡಿರುವುದಿಲ್ಲ. ಈ ಬಗ್ಗೆ ಗ್ರಾಮಗಳಿಗೆ ಖುದ್ದು ಭೇಟಿ
ಹಲವು ಸಭೆಗಳಲ್ಲಿ ಮೌಖಿಕವಾಗಿ ತಿಳಿಸಿದರೂ ಸಹ ಇದುವರೆಗೂ ಯಾವುದೇ
ಕ್ರಮ ಕೈಗೊಳಿಸುವುದು ಕಂಡು ಬರುವುದಿಲ್ಲ. ಎಟ್ಸೆಟ್ರಾ. ನಾವು ಪ್ಲೀಸ್ ಲುಕ್ ಎಟ್ ಹಿಸ್ ಎಕ್ಸ್ಪ್ಲನೇಷನ್. He says, ನಾನು ಅಲ್ಲಿ ಹೌದು ಬೆಂಗಳೂರಿಂದ ಬರ್ತಾ ಇದ್ದೆ, ಈಗ ನಾನು ಯಾರೋ ರಿಲೇಟಿವ್ ಮನೆಯಲ್ಲಿ ಇದ್ದೀನಿ ಅಂತ ಹೇಳಿ ಅದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಲಿಲ್ಲ. ನಥಿಂಗ್ ಇಸ್ ಪ್ಲೇಸ್ ಬಿಫೋರ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ಸ್. Along with our objections, we have filed it.
He said, ನೀವು ಬರೋದು ಗೊತ್ತಿರಲಿಲ್ಲ, ಕಡತ ಒಂದರ ಚರ್ಚೆಗಾಗಿ ನಾನು ಒಂದು 9:30ಕ್ಕೆ ಮಾನ್ಯ ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳನ್ನು ಭೇಟಿ ಮಾಡಲು ಕೋಲಾರಕ್ಕೆ ಹೋಗುತ್ತಿದ್ದಾಗ ತಾವು ಕಚೇರಿಗೆ ಭೇಟಿ ನೀಡಿರುವ ವಿಷಯ ನನಗೆ ಕಚೇರಿ ಸಿಬ್ಬಂದಿಗಳು ದೂರವಾಣಿ ಕರೆ ಮಾಡಿ ತಿಳಿಸಲಾಗಿ ನಾನು ಮಾರ್ಗ ಮಧ್ಯೆ ವಾಹನವನ್ನು ಹಿಡಿಸಿಕೊಂಡು ಆತುರ ಕಚೇರಿಗೆ ಆಗಮಿಸಿದಾಗ ತಾವು ಬೂದಿಕೋಟೆ ಕಡೆಗೆ ಹೋದಿರಿ ಎಂಬುದಾಗಿ ತಿಳಿದು ಬಂದು ತಮಗೆ ಈ ಬಗ್ಗೆ ಕರೆ ಮಾಡಿದಾಗ ಕೆಲಸವನ್ನು ಮುಂದುವರಿಸಿ ಎಂದು ಸೂಚನೆಗಳನ್ನು ನೀಡುತ್ತೀರಿ. ಅದರಂತೆ ನಾನು ದಿನನಿತ್ಯದ ಕರ್ತವ್ಯದಲ್ಲಿ ತೊಡಗಿಸಿಕೊಂಡಿರುತ್ತೇನೆ. ನಾನು ಬಂಗಾರಪೇಟೆ ತಾಲೂಕು ಒಂದು ಕರ್ತವ್ಯಕ್ಕೆ ವರದಿ ಮಾಡಿಕೊಂಡಿದ್ದು ಕೇವಲ 27 ದಿನಗಳಷ್ಟೇ ಕಳೆದಿರುತ್ತದೆ. ಆರಂಭದ 1-2 ದಿನ ಅಷ್ಟೇ ನಾನು ಬೆಂಗಳೂರಿನಿಂದ ಟ್ರಾವೆಲ್ ಮಾಡಿದ್ದು. ಕಳೆದ 15 ದಿನದಿಂದ ಬಂಗಾರಪೇಟೆ ನನ್ನ ಸಂಬಂಧಿಕರ ಮನೆಯಲ್ಲಿಯೇ ಇದ್ದುಕೊಂಡು ಕೇಂದ್ರ ಸ್ಥಾನದಲ್ಲಿಯೇ ವಾಸವಿರುತ್ತೇನೆ. ಸರ್ಕಾರದಿಂದ ನಿಗದಿಪಡಿಸಿರುವ ಹಲವು ಜನಗಳಂತ ಆಧಾರ್ ಸೀಡಿಂಗ್ ಲ್ಯಾಂಡ್ ಬಗರ್ ಹುಕುಂ ಪ್ರಗತಿ ಸಾಧಿಸುವ ಅವಶ್ಯಕತೆ ಇದ್ದು ಈ ಬಗ್ಗೆ ಸತತವಾಗಿ ಮೇಲ್ವಿಚಾರಣೆ ಮಾಡಿದ್ದು ಲ್ಯಾಂಡ್ ಬೀಟ್ ನಲ್ಲಿ 100% ಪ್ರಗತಿ ಸಾಧಿಸಲಾಗಿದೆ. 100%. ಸದರಿ ಆಧಾರ್ ಸೀಡಿಂಗ್ ನಲ್ಲಿ ಜುಲೈನಲ್ಲಿ ಬಂಗಾರಪೇಟೆ ತಾಲೂಕು 2ನೇ ಸ್ಥಾನದಲ್ಲಿ ಇರುತ್ತದೆ. ರಾಜ್ಯಕ್ಕೆ ಹೋಲಿಸಿದಾಗ ಮೇಲಿನ ಶ್ರೇಣಿಯಲ್ಲಿ ಗಮನಾರ್ಹ ಪ್ರಗತಿಯನ್ನು ಸಾಧಿಸಲಾಗಿದೆ. ಹೀಗಾಗಿ ದಯಾಪರ ತಾವುಗಳು ನೀಡಿರುವ ಕಾರಣ ಕೇಳು ನೋಟಿಸ್ ನಲ್ಲಿ ಹೇಳಿದ ಅಂಶಗಳನ್ನು ನನ್ನ ಲೋಪದರ್ಶನದ ಸದರಿ ಕಾರಣ ಕೇಳು 24/8/2024. This was August 2024.
Correct.
Thereafter, any inquiries initiated against?
No.
No
The
inquiries.
MLA's letter, my lords, get that, my lord, at running page. Hmm. 120, correct. Nama objection statement alli.
You represent whom?
I represent the
Beneficiary.
Tahsildar, my lord, who has been posted there.
Posted.
120 tav bandre.
120.
Yes, my lord.
Petition na? Petition of 120 no athwa?
Statement of objections. Allah.
Petition
32 of the statement of objections, my lord.
32 of statement of objections.
Amdu. Or force, my lord, objection statement.
Same as 32. ಅಲ್ಲಿ ಲೋಕಲ್ MLA
Yes,
ಲೆಟರ್ ಈ
ಮೇಲ್ಕಂಡ ವಿಷಯ ಸಂಬಂಧಿಸಿದ ತಮ್ಮಲ್ಲಿ ತಿಳಿಸುವುದೇನೆಂದರೆ ಕಂದಾಯ ಇಲಾಖೆ ಅಧಿಕಾರಿಯಾದ ವೆಂಕಟೇಶಪ್ಪ ಹಾಲಿ ಬಂಗಾರಪೇಟೆ ತಾಲೂಕಿನ ತಹಸೀಲ್ದಾರರಾಗಿ ಕರ್ತವ್ಯ ವಹಿಸುತ್ತಿದ್ದು ಸದರಿಯರು ಕಚೇರಿಗೆ ಸಮಯಕ್ಕೆ ಸರಿಯಾಗಿ ಹಾಜರಾಗದೆ ಸಾರ್ವಜನಿಕರ ಕುಂದುಕೊರತೆಗಳಿಗೆ ಸ್ಪಂದಿಸುವುದಿಲ್ಲ ಎಂಬ ದೂರುಗಳು ನನಗೆ ಬಂದಿದ್ದು ಸದರಿಯರ ಕಾರ್ಯವಕೇರಿಯ ಬಗ್ಗೆ ಸ್ಥಳೀಯರು ನನ್ನ ಬಳಿ ಅಸಮಾಧಾನ ವ್ಯಕ್ತಪಡಿಸುತ್ತಿದ್ದಾರೆ. ಪ್ರಸ್ತುತ ಕೋಲಾರ ಜಿಲ್ಲೆಯ ಕಚೇರಿಯಲ್ಲಿ ಮುಜರಾಯಿ ತಹಸೀಲ್ದಾರಿಗೆ ಕರ್ತವ್ಯ ನಡೆಸುತ್ತಿದ್ದ ಶ್ರೀಮತಿ ಸುಜಾತಾರವರ ಬಗ್ಗೆ ಕಾರ್ಯವಕೇರಿಯ ಬಗ್ಗೆ ಸಾರ್ವಜನಿಕರು ಶ್ಲಾಘನೀಯ ಅಭಿಪ್ರಾಯವನ್ನು ನೀಡಿ ಸದರಿಯವರನ್ನು ಬಂಗಾರಪೇಟೆ ತಾಲೂಕಿನ ನೂತನ ತಹಸೀಲ್ದಾರಿಗೆ ವರ್ಗಾಯಿಸಿ
ಎಷ್ಟು ದಿವಸ ಆಗಿತ್ತು ಇವ್ರು ಬಂದಲ್ಲಿಗೆ? 22
ಇವ್ರು ಬಂದು
22 days.
ಇಲ್ಲ 4.5 months ಅಲ್ಲ.
4 months.
No,
4 months.
as on the date you issued 15
On that day, it was his 22nd day.
22nd day.
This letter, my lord.
ಹೌದು 13/12/2024.
Correct.
13-12, my lord, so that is.
4 months.
That is
4 months thereafter.
29th,
one nimsha.
29th.
Please come to my lord. The order, my lord, passed by the, my lord.
He came to that post when Mr. Hulla?
My lord, he came to the post on, my lord, 11/5/2000.
Sorry, 1st August 2024.
1/8/2020.
1/8/2024.
This, my lord, then, my lord, the Tahsildar, my lord, the Deputy Commissioner, my lord, gives saying that, you are not in the, that was in August. This is, my lord, in December, after 4.5 months.
He refers to that letter.
He refers to that letter only.
He puts it in the first paragraph with inverted commas.
My lord,
Kindly see your
yes.
letter.
Please come to, my lord, page 32 for a minute.
Letter.
Page 32 ಅಲ್ಲಿ letter ಇಲ್ಲ. It doesn't relate to, my lord, that letter of the Deputy Commissioner or the show cause notice.
That is what
The
they
Deputy
refer
Commissioner refers to that letter.
Deputy Commissioner, my lord, no, Deputy Commissioner says you did not, my lord, this is 4 months later. In fact, in this regard, my lord, just have a look at, my lord, the judgment that I have given to your lords is 2024, paragraph 12 of that.
MLAs can always seek.
No, not only
good
that.
officers.
It can't be said. Paragraph 12, my lord. You involved in the present case is somewhat similar to the case of Muhammad Masood Ahmad versus State of UP, 2007 8 SCC 150, wherein in paragraph 8, as observed, is thus. In our opinion, even if the allegation of the appellant is correct, that he was transferred on the recommendation MLA, that by itself would not vitiate the transfer order. After all, it is the duty of the representative of the people of the legislature, in the legislature, to express grievance of the people, and if there's any complaint against an official of the sound, so it's certainly within its jurisdiction to transfer charge. Therefore, my lord, my submission please permit me. I have never, when you argued, I did not even open my mouth. If you don't, please, if you don't mind.
Yes.
Then, my lord, the transfer also, my lord, please look at it. From 16 kilometers is all that, my lord, 14 kilometers is the distance from where he is and, my lord, where he is now transferred. Therefore, my lord, that is one aspect, but more important is Deputy Commissioner, my lord, also, my lord, found that, my lord, he has not been regularly coming. Therefore, my lord, he should be
No, only on one day.
One day.
He was absent in the sense, he said, I am in the office of the jurisdictional assistant commissioner.
Can I persuade your lordship to
Very,
get, my lord,
very,
that paragraph?
very.
Permit me to read, my lord, aloud, page 128.
128. Yes.
ಸಾರ್ವಜನಿಕರಿಗೆ ಮಿಲಾಡ್ 1, 2, 3, 4, 5, 6, 7, 8 ಲೈನ್ಸ್. ಆದರೂ ಸಹ ಕಚೇರಿಗೆ ಸರ್ಕಾರಿ ಅಧಿಕಾರಿ ನೌಕರರು ತಮ್ಮ ಕೇಂದ್ರ ಸ್ಥಾನದಲ್ಲಿ ವಿರದೆಂಬ ಸರ್ಕಾರದ ನಿರ್ದೇಶನವಿದ್ದರೂ ಸಹ ತಹಸೀಲ್ದಾರದ ನೀವು ಕೇಂದ್ರ ಸ್ಥಾನದಲ್ಲಿ ವಾಸವಿರದೆ ಹಾಗೂ ಸಾರ್ವಜನಿಕರಲ್ಲಿ ಲಭ್ಯವಿಲ್ಲದೆ ಪ್ರತಿದಿನ ಬೆಂಗಳೂರಿನಿಂದ ಪ್ರಯಾಣಿಸುತ್ತಿರುವ ತಿಳಿದು ಬರುತ್ತದೆ. ಈಗಾಗಲೇ ಸರ್ಕಾರದಿಂದ ನಿಗದಿಪಡಿಸಿದ ಹಲವಾರು ಯೋಜನೆಗಳಾದಂತಹ ಆಧಾರ್ ಸೀಡಿಂಗ್, ಲ್ಯಾಂಡ್ ಬಿಡ್, ಬಗರ್ ಹುಕುಂ ಇತರೆ ಕೆಲಸಗಳಲ್ಲಿ ಪ್ರಗತಿ ಸಾಧಿಸುವ ಅವಶ್ಯಕತೆ ಇದ್ದು, ಇದು ಯಾವುದರಲ್ಲೂ ಯಾವುಗಳ ಬಗ್ಗೆ ಮೇಲ್ವಿಚಾರಣೆ ಮಾಡಿರುವುದಿಲ್ಲ. ಈ ಬಗ್ಗೆ ಗ್ರಾಮಗಳಿಗೆ ಖುದ್ದು ಭೇಟಿ
ಈ ಬಗ್ಗೆ ಸತತವಾಗಿ ಮೇಲ್ವಿಚಾರಣೆ ಮಾಡಿದ್ದು ಲ್ಯಾಂಡ್ ಬೀಟ್ ನಲ್ಲಿ 100% ಪ್ರಗತಿ ಸಾಧಿಸಲಾಗಿದೆ
ಅಂತ ಅವ್ರು ಹೇಳಿದ್ದಿಲ್ಲ.
ಆಧಾರ್ ಸೀಡಿಂಗ್ ಇದನ್ನ ದಿನ ಆಮೇಲೆ ಎಲ್ಲಿ ಇದನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಲ್ಲಲ್ಲ ಯಾರು? ಹೂ ಎಕ್ಸಾಮಿನ್ಡ್? 100% ನಾ ಕೆಲಸ ಮಾಡೀನಿ ಅಂತ ಹೇಳಿಕತ್ತಾನು. ಅವ್ರು ಅದ್ರ ಮೇಲೆ ಡೆಪ್ಯೂಟಿ ಕಮಿಷನರ್ ರಿಪೋರ್ಟ್ ಎಲ್ಲಿ ತರ್ಸ್ಕೊಂಡ್ರಿ ನೀವು?
128 ಏನಾಗಿದೆ? 128 is the one which is
128 is reply to
reply.
reply.
100%
ಮಾಡೇನಿ ನಾನು ಅಂತ.
2480 100%.
ಇಲ್ಲ, ನೀವೊಂದು ಇದು ಕಳಿಸಿದ್ರಿ.
ಒಂದ್ ನಿಮಿಷ ಅವರಿಗೆ ಡಿಸ್ಟರ್ಬ್ ಮಾಡಬೇಡಿ ಇರಿ, ಅದು ಸ್ವಲ್ಪ ಡಿಸ್ಟರ್ಬೆನ್ಸ್ ಆಗ್ತದೆ, ಸ್ವಲ್ಪ ಇರಿ. ಅವ್ರು ಮಾಡುವಾಗ ಆಮೇಲೆ ನಿಮ್ ನೋಡಿ ಬೇರೆಯವರೆಲ್ಲ ಸ್ಟಾರ್ಟ್ ಮಾಡಿಬಿಡ್ತಾರೆ. ನಮಗೂ ಪ್ರಾಬ್ಲಮ್, ಅವ್ರಿಗೆ ನಾವ ಇಂಟರ್ಫಿಯರ್ ಆಗೋದು ಜಾಸ್ತಿ.
ಈಗ ಏನಾಗಿದೆ, ನಮ್ಮಲ್ಲಿ ಶಟಲ್ ಕಾಕ್ ಬ್ಯಾಟ್ ಮಲಡ್ ಕೋರ್ಟ್ ಇದೆ, ಕೋರ್ಟ್ ಆಫ್ ಲಾ ಇದೆ. ಶಟಲ್ ಕಾಕ್ ಅಲ್ಲಿ ಒಂದ್ಸಲ ಟಂಗ್ ಅಂತ ಆ ಕಡೆ ಹೊಡೆದು ಇನ್ನೊಂದ್ಸಲ ಇವ್ರು ವಾಪಸ್ ಹೊಡಿತಾರೆ. ಅದು ಮಾಡಬಾರ್ದು. ಇದರಲ್ಲಿ ಅದಕ್ಕೆ CPC ನಲ್ಲಿ ಯಾವ ತರ ಹೋಗ್ಬೇಕು, ಹೇಗ್ ಹೋಗ್ಬೇಕು, ಏನು ಎತ್ತ ಅಂತಿದೆ ಎಲ್ಲ ಬಿಟ್ಟು ಈಗ ನಾವು ಇವ್ರು ಮಾತಾಡೋ ನಾನು ಬಾಯಿ ಮುಚ್ಚಿರ್ತೀನಿ, ಯಾರು ಮಾತಾಡೋದಿಲ್ಲ ನಾನು. ಆದ್ರೂ ಪ್ರತಿ ಸರ್ತಿ 2 ಸೆಂಟೆನ್ಸ್ ಆದ ತಕ್ಷಣ ಒಂದು ಇದಾಗತ್ತೆ. ಪ್ಲೀಸ್ ಕಮ್ ಟು ಮಲಾಡ್ ರನ್ನಿಂಗ್ ಪೇಜ್.
ಟಾಲ್ ಮೆಂಬರ್ಸ್,
ಐ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್.
ಬಟ್ ಏನಾಗ್ತದೆ, ಸ್ವಲ್ಪ ಡಿರೇಲ್ಮೆಂಟ್ ಆಗ್ತದೆ. ನಾವು ಇಂಟರ್ಫಿಯರ್, ಇವನ್ ಕೋರ್ಟ್ ಇಂಟರ್ಫಿಯರ್ ಆದ್ರೂ ಡಿರೇಲ್ಮೆಂಟ್ ಆಗ್ತದೆ. ನಾವು ಮಾಡಬಾರ್ದು. ಬಟ್ ಎಲ್ಲೋ ನಾವು ಒಂದ್ ಕಡೆ ಓದ್ಕೊಂಡ್ ಬಂದೇವಿ ಅನ್ನೋದಕ್ಕೆ ಸ್ವಲ್ಪ ಕೇಳ್ತೇವೆ ಅನ್ನೋದು ಬಿಟ್ರೆ, ಅವರ ಅಬ್ಜೆಕ್ಟ್ ಇಸ್ ನಾಟ್.
No, your lordships, my lord, whatever doubts your lordships have, definitely your lordships will have to ask, my lord.
That's what.
Unless we, my lord, clarify the doubts.
ಗೊತ್ತಾಗುದಿಲ್ಲ.
No,
I tell you, you should thank the judges
absolutely
in one way. Otherwise, ನಾವೆಲ್ಲ ನಿಮ್ದು ಕೇಳ್ಕೊಂಡ್ರೆ
ಏನ್ ಡೌಟ್ ಇದೆ ನಿಮ್ಗೆ ಗೊತ್ತಾಗದೇ ಇದ್ರೆ we will not clarify it. I never object.
Clarify ಮಾಡಿ hearing.
Absolutely. All the time saying is, ನಾವು ಇವ್ರು ಮಾತಾಡುವಾಗ ಇಬ್ರು ಎರಡು ಮಾತಾಡಿದ್ರೆ ನಿಮ್ಗೆ ಇರೋದು 2 ಕಿವಿ 4 ಕಿವಿ ಅಲ್ಲ ಅಂತ ಇಷ್ಟೇ ಹೇಳೋದು, ಇನ್ನಿಗಿಂತ ಹೆಚ್ಚು ಹೇಳೋದಿಲ್ಲ.
Yes. Yes.
So what?
ಎಷ್ಟು ವರ್ಷ ಸರ್ವಿಸ್ ಆಗಿದೆ ನಿಮ್ಮ ಕ್ಲೈಂಟಿಗೆ?
How does it matter?
2015
2015 ಅಪಾಯಿಂಟ್ಮೆಂಟ್.
batch.
ಆ ಲೇಡಿಗೆ
ಅವರು I have no idea.
she is of which year? That lady Tahsildar.
I think she is a promotee to the cadre.
Promotee of the Tahsildar cadre.
To the Tahsildar cadre. Shirisdar in the grade 2 Tahsildar.
When she came to
Karnataka, because it is
91 appointment.
91 appointment as appointed as SDA. Yes, all right. Whether any complaint is there against Mr. Holla, against your client?
There
Any
was
Lokayukta complaint, etc.
complaint ittala, stay agide.
Mr. EGA, AAG,
That is stayed.
but there is a complaint.
There's a complaint that is stayed, my lord. Please come to
There's an FIR.
FIR also.
FIR is, my lord, filed, that is stayed.
That is stated.
Not, my lord, complaint is only in the FIR. Please come to, my
What is
lord.
the complaint?
Yes, my lord. Please come to, my lord, annexure A, page 75
Of
of, my
petition.
lord, my objection statement.
Objections.
And we did not even deal with that file. Our higher officials will not dealt with that file. Vijayanna ಅವರು ಘನ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ರಿಚರ್ಡ್ so and so. Tahsildar, Vijayanna my lord is a Tahsildar.
What are these offenses? What is the penalty, punishment? How many years of punishment, imprisonment? 409, 420, 460, what is IPC? 7 years, sir.
That is my lord stated by this honorable court on the next page, page 82. Two, my lord. At 83, my lords get that. 82 at 83.
Seven years. Well, the remaining is 468, 465, 468, 34. Who had lodged the complaint? Lokayukta. It's a
One
Lokayukta
journalist, my
complaint.
lord. Journalist lodged a complaint against the Tahsildar. I was working under him. Please come to my lord, page 76.
76.
That's all right. Tahsildar my lord Vijayanna, Dayananda Tahsildaru, Balaji Vishay Nirvahakara Virudha. PC Kaideyadi, so and so, so and so, so and so. I was working my lord as a KGF.
Yes. Any inquiry against?
No inquiry to my knowledge.
I'll just verify. I'll verify. Notes, can I just make a few submissions?
ಒಂದು ನಿಮಿಷ ಅವ್ರದ್ದು ಮುಗಿದಿದ್ರೆ
ಇಲ್ಲ, ಇಲ್ಲ,
ಪ್ರಶ್ನೆ
ಅವ್ರು
ನಮ್ದು
ಮುಗ್ದ್ಮೇಲೆ
ಇಷ್ಟ ಇನ್ನೆಂತದ್ದು ನಾವು ಇಷ್ಟೇ ಹೇಳೋದು ಒಂದು Malord, the Deputy Commissioner himself, Malord, had initiated, Malord, in 2000, Malord, I mean, August itself. Thereafter, Malord, if your lordships, Malord, come to Malord, my objection statement.
What
Otherly-
Deputy Commissioner initiated, he issued notice,
Correct, correct.
he replied.
Please come to Malord, page 72 of my objection statement.
72.
Even as on 7/12, Kali Kurchi ide, alli avaru ilve illa.
ತಹಶೀಲ್ದಾರ್ದು ಜಾಬ್ ಚಾರ್ಟ್ ಇದೆಯಾ? Do you have job chart of the ತಹಶೀಲ್ದಾರ್?
Notes, I'll get it. Job.
ಅವ್ರದ್ದು ಇರುತ್ತಲ್ಲ ಜಾಬ್ ಚಾರ್ಟ್ ಏನೇನ್ ಮಾಡ್ಬೇಕು, ಹೊರಗೆ ಅಲ್ಲಿ ಹೋಗ್ಬೇಕು, ವಿಸಿಟಿಂಗ್ ಏನೇನ್ ಮಾಡ್ಬೇಕು ಅನ್ನೋ ಬಗ್ಗೆ. Do you have that?
It's not right now, notes, I'll get it.
All right, adana.
ಗೂಗಲ್ ನಲ್ಲಿ ತೆಗಿ.
Justice Govindra's judgment.
Padi.
I've summoned for additional copies. This is from
Okay.
the compilation. My lord. Para 11.8 in the first judgment.
7.8.
And it also follows Honorable Justice N. Kumar's judgment in para 10, my lord, which is also behind. Para 11.8.
ಒಂದ್ಸರಿ ನೋಡ್ಕೋತೀರಿ ನಿದ್ನ
ಆಗ್ಬೋದು,
ನೋಡ್ಕೊಂಬನ್ನಿ.
ಆಗ್ಬೋದು. ಆಯ್ತು,
ಇಲ್ಲ ಕಾಲ್ ದಿಸ್ ಮ್ಯಾಟರ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಇಟ್ಕೊಂಡಿರ್ತೇವಿ,
ಆಗ್ಬೋದು.
ಸ್ವಲ್ಪ ನೋಡ್ಕೊಂಬನ್ನಿ.
ಆಯ್ತು.
ನೀವು ನೋಡ್ಕೊಂಬನ್ನಿ.
ಖಂಡಿತ. Malord, ultimately your lordships will be laying down the law.
ಇಲ್ಲ ಲಾ ಲೇ ಡೌನ್ ಆಗ್ಬಿಟ್ಟು ಅಪ್ಲೈ ಇದ್ದಲ್ಲ ಒಂದು ಕೆಲವು ಫೈನಲ್ ಆಸ್ಪೆಕ್ಟ್ಸ್ ಇದೆ
It's all.
ವಿಚ್ ವಿಲ್ ಡೀಲ್
I'll also get.
ನೀವು ನೋಡ್ಕೊಂಬರ ಎಲ್ಲ ಅಪ್ಡೇಟ್ ಮಾಡ್ಕೊಂಬರ್ಬೇಕು.
Please, notes.
ಒಂದು
Applicant ಮೇಲೆ ಏನಾದ್ರು ಇದೆ?
ಹಾ ಅಪ್ಲಿಕೆಂಟ್ ಮೇಲೆ ಏನ್ರ ಇದೆಯಾ, ಎರಡನೇದು
Tahsildar job.
ಇದನ್ನ ಈ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಅಲ್ಲದೆ ಆ ಲೇಡಿ ಮೇಲೆ ಬೇರೆ ಡಿಸಿಪ್ಲಿನರಿ ಎನ್ಕ್ವೈರಿ ಏನ್ರ ಇದೆಯಾ?
Please.
ಅದನ್ನೆಲ್ಲ ನಮ್ಗೆ ಫೈಲ್ ತೋರಿಸ್ಕೊಡ್ಬೇಕು.
Please.
ಇವ್ರದ್ದು ಕೊಡ್ಬೇಕು, ಅವ್ರದ್ದು
Out.
ಕೊಡ್ಬೇಕು.
Then I'll also get the job chart of the Tahsildar.
ಜಾಬ್ ಚಾರ್ಟ್ ಆಫ್ ದಿ ತಹಶೀಲ್ದಾರ್ ಕೊಡ್ಬೇಕು.
And what happened to the show cause notice in the month of eighth month. If it-
ಅದಾದ್ಮೇಲೆ ಏನಾಗಿದೆ?
Their assertion is that it was closed on the reply that was received. But the complaint my lords that has come out from the minister, from the local representative is in the month of December. Whether again there was subsequent incidents of absence after the show cause notice, I'll also get.
ತಿಳ್ಕೊಂಡು ಹೇಳ್ಬೇಕು.
Please, my lords.
ಮತ್ತೆ ಮೈಂಡ್ ಆಫ್ ದ ಕೋರ್ಟ್ ನಲ್ಲಿ ಏನಿದೆ ಅನ್ನೋದನ್ನು ತಿಳ್ಕೊಬೇಕು.
Please.
ಅದಕ್ಕೆ ಬೇಕಾಗೋ ಮಟೀರಿಯಲ್ ತೊಂಬರ್.
Please,
So one submission I would like. All these letters of the MLA started after 30th November 2024. What happened in the Bogorukam meet committee that is available at page 130 of my writ petition. ಅದು next page. ಅದಾದ್ಮೇಲೆ ಬರೀತಾರೆ ಲೆಟರ್ಸ್ ಅವರು.
ಏನ್ ನಾವು ಇದ್ರ ಲೆಟರ್ ಸಿಗಿಲ್ಲ.
ಲೆಟರ್ಸ್ ಅಲ್ಲ.
ಯಾಕಂದ್ರೆ ಏನ್ ಬೇಕಾದ ಲೆಟರ್ಸ್ ಬರ್ಸ್ಕೋಬಹುದು ಈಗಿನ ದಿವಸದಲ್ಲಿ, ಏನ್ ಬೇಕಾದ ಪಬ್ಲಿಷ್ ಮಾಡಿಸ್ಕೋಬಹುದು.
ಹೌದು. ಆಮೇಲೆ ಕೈಂಡ್ಲಿ only one letter, page 120 ಲಿ, all right, he may not be satisfied with my services and all that. He says, who should be brought in my place?
MLA ಗಳಿಗೆ ಮತ್ತೆ ಸ್ವಲ್ಪ ಕೊಡ್ಬೇಕು. ಆದ್ರೆ ತೀರಾ ಇಂಟರ್ಫಿಯರೆನ್ಸ್ ಆಗೋದು ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಗೆ ಎಲ್ಲರೂ ಬೆಕ್ ಅಂಡ್ ಕಾಲ್ ಆಫ್ MLAs ಆಗಿಬಿಟ್ರೆ ಮುಂದ್ ಕೆಲಸ ಮಾಡೋದು ಹೇಗೆ? ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಇಂಡಿಪೆಂಡೆಂಟ್ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಇರ್ಬೇಕು ನಮಗೆ. ನಾಳೆ ಕೆಲಸ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ. ಆಮೇಲೆ ಹಿಂಗೆಲ್ಲ ಅದಕ್ಕೆ ನೋಡು ಬಗರುಕಮ್ಮನ್ನೆಲ್ಲ ಮಾಡೋದು ಹೇಳ್ತಾ ಜಸ್ಟ್ ಎಕ್ಸಾಂಪಲ್.
No, I understand.
Even
I understand.
And
Ultimately,
he is a
there has to be a
statutory
balance.
authority.
Please.
Tahsildar is a statutory authority, at least in 6 statutes. ಹಂಗಾಗಿ ಅಗದಿ ಸ್ಪೈನ್ಲೆಸ್ ಆಗಿ ಕೆಲಸ ಮಾಡಕ್ ಆಗಲ್ಲ ಅವನಿಗೆ. ಸ್ವಲ್ಪ ಬಿಗಿ ಇರ್ಬೇಕಾಗ್ತದೆ ತಹಶೀಲ್ದಾರ್.
No, these allegations that now they are making.
ಅಯ್ಯೋ, ಅಪಾರ್ಟ್ ಫ್ರಮ್ CRPC ನಾನು ಹೇಳಿದ್ದು 6 legislation ದಲ್ಲಿ he is an authority who works
The
on
Land Revenue Act correct.
autopsy he orders.
Land Revenue Act ಇಂದ ಹಿಡ್ಕೊಂಡು
So many
These allegations were not before the court of the first instance. It has come up, my lords, after, my lords, if they are making allegations, my lords, that it was at the, after the Bagirukum committee, whatever newspaper reports they are alleging, it is literally alleging, my lords, malafides against the elected representative. Then, my lords, he might have to be made a party if they are going to that extent.
ಅಲ್ಲ, legal malafide ಗೆ
Legal malafides, my lords, party is.
ಫ್ಯಾಕ್ಚುಯಲ್ malafide ಮಾಡೋದ್ ಬೇಕಾಗ್ತದೆ. ಎನಿವೆ ಇದು ಅಷ್ಟು ಸಿಂಪಲ್ ಆಗಿಲ್ಲ.
Please.
ಅಷ್ಟು ಸಿಂಪಲ್ ಆಗಿಲ್ಲ.
Please.
ಎನಿವೆ ವಿ ವಿಲ್ ಡೀಲ್ ದಟ್. ಅಲ್ಲಿ ಸ್ಟೇ ಇದೇನೆ ಈಗ.
Stay.
Interim order to heard further, ಅಲ್ಲ heard in part. Call this matter week after next. Till then, interim order would continue. ಇದು ಬೇಡ, ಇದನ್ನೊಂದು ಕಾಪಿ ಇಟ್ಕೋಬೋದ ನಾವು?
Lords, that can be in the court file itself.
ಬರ್ಕೊಳ್ಳಿ. We appreciate the gesture of learned AG in placing the photostat copy of file.
The E-file.
ಎಂತ ಫೈಲ್ ಇದು?
E-file.
E-file with us. Yes. Okay.
Grateful.
Okay. ಯಾವುದು? ಕೊಡಿ. ಪಾಸ್ವರ್ಡ್ ಇದೆ.
32 ಮೇಲೆ.
32. 32 ಆಯ್ತದ. ಯಾವ್ದೋ ಮುಂದಿನ ಯಾವ್ದೋ ಡೇಟ್ ಹಾಕಿವಿ. ನೆಕ್ಸ್ಟ್. ಮುರಳೀಧರ್. ಏನದು?
Petitioner is denied professor's CAS benefit. My lords are very well aware that CAS is only a time-bound advancement type. It is not a promotion as such.
Correct.
It's only to not to any post as such, because there won't be any cadre of professor in this. He was denied the CAS benefit, my lord, on the ground that, my lord, on the date of passing of the order, he had already become the employee of the Maharani's Cluster University. That happened in the month of June. On 36/2022, he became the employee of the Cluster University. But what the UGC regulation says, as on the date of consideration of
ಆ ಡೇಟ್ ಏನಿತ್ತು ಅದು ಬೇಕು ಅಂತ.
ಅಷ್ಟೇ consideration.
ಇಂಪ್ಯೂನ್ಡ್ ಆರ್ಡರ್ ಅಲ್ಲಿ.
Impugned order, my lord, impugned order is that, my lord, I have not been included in the list. I have not been included in the list of the candidates who were called for the next process. I was denied in
ಮತ್ತೆ ಯಾರು ಲಿಸ್ಟ್ ತಯಾರು ಮಾಡ್ತಾರೆ?
second respondent, Commissioner.
Why his name was not included?
But in this matter, I've sought for instructions, my lord. I received the file for the first time. Matter relates to career advancement scheme for
CAs.
the professor.
ಅದೇನ ಪ್ರಮೋಷನ್ ಅಲ್ಲ?
It involves movement from one academic grade paid to another, my lord.
ಅದು only in terms of pay.
Please, please.
ಹಂಗಾಗಿ post
It
based
does away with post-based, vacancy-based promotion, my lord.
not vacancy based.
It does away with vacancy-based promotion. It obviates a lot of conflicts which arose as a result of seniority and promotion. Adopting of this scheme, my lord. But I just need some time for getting instructions. I've
ಯಾವತ್ತು ಮಾಡ್ಸಿ?
already requested them for information, my lord.
ಯಾವತ್ತು?
Any early date, my lord. Any day convenient. to
ನೀವು
your
ಡೇಟ್ ಚೂಸ್ ಮಾಡಿ. ಅವತ್ತು ನಾವು ಮತ್ತೆ ಟೈಮ್ ಕೊಡಲ್ಲ.
ಆಗು.
ಚೂಸ್ ಡೇಟ್ ಫ್ರಮ್ ದ ಕ್ಯಾಲೆಂಡರ್. ಕ್ಯಾಲೆಂಡರ್ ಇಸ್ ಫುಲ್ ಆಫ್ ಡೇಟ್ಸ್.
Lord, 7th, my lord. April 7th.
Call this matter on 7th.
Okay, please.
7th. First, this date is fixed at the instance of Ladnedi AGA. Finally,
Please.
two 30%. 120 cost. First. ಎರಡಿದಾವ? All right. Two disposals. ಹೌದು, ಹಾಗೆ just ಬರ್ತು.
120, 115.
ಬರ್ತೀನಿ.
ಈಗ ನನ್ ಏನಿಲ್ಲ ಸರ್, ಮ್ಯಾಟರ್ ಇಸ್ ವೆರಿ ಸಿಂಪಲ್. CAS is not for any, tell you frankly, CAS is only ಇದು, when once a person retires, the post will go back to the original post of lecturer. That is the thing. And the regulation is there. Only thing is that ಏನಂತಂದ್ರೆ, the persons who are given the CAS benefit, they have been later retrospective effects in our benefit. That means that retrospective effects in the ಕೊಟ್ಟಾಗ it won't go along with the postal title.
So 230 picture.
120 को चैम्बर में ब्लूटूथ देख के वो फिल्म बाद में इधर आएंगे वापस में बाद में 2 मैटर 230 तो ಹೇಳಿದ್ರಲ್ಲಿ ಹೇಳಿದ್ರಲ್ಲ ಇದು 125 ಅವ್ನು ಇರ್ಲಿಲ್ಲ ಅವ್ರು 230 125 ಜಾಸ್ತಿ ಇದೆ 5 ಅದೇ ಯಾಕೆ ನಮ್ ಚೇತನ ಹೇಳ್ತಾರಲ್ಲ ನಿಮ್ದು ಸಿಂಗಲ್ ಮೇಡಮ್ ಹೌದು ನಮ್ದಿದೆಲ್ಲ ನಿಮ್ ಸಿಂಗಲ್ ಆಗ್ತದೆ 10 ಮ್ಯಾಟರ್ ಆಗ್ತದೆ ಯಾರು ಮುಗಿಸ್ತಾರೆ 10 ಮ್ಯಾಟರ್ ಆಗ್ತದೆ ಇಲ್ಲ ನಾಳೆ ಹೇಳಿಲ್ಲ ಕೊಟ್ಟಿರೋದು ಗೊತ್ತಿಲ್ಲ ಡಿಸೈನ್ ಮಾಡ್ತಾರೆ ಬೋರ್ಡ್ ಅವ್ರ ಮುಂದೆ ನಾವೊಂದು ಡೇಟ್ ಕೊಟ್ಟಿದ್ವಿ ಅಷ್ಟೇ ಸರ್ ಪ್ರದೀಪ್ ಹಿಂಗ್ ಇರೋದಂತೆ ಇನ್ನೊಂದು ಅವತ್ತು ಇದಕ್ಕೊಂತಾರಂತೆ ಇನ್ನೊಂದು 4 ಎಲ್ಲೋ ಮೆಮೋಸು ನಾಳೆ ಬಂದ್ಬಿಡ್ಬೇಕು ಅಂದ್ರು ಮೇಡಮ್ ಎಲ್ಲೋ ಮೆಮೋಸು ಬಂದ್ಬಿಡ್ಬೇಕು ಅಂದ್ರು ಈಗ ನಾಳೆಗೆ ಸ್ವಲ್ಪ ಮ್ಯಾಟ್ರ್ ಹಾಕ್ಸಂತಾರೆ ಹಾ? ಪ್ರದೀಪ್ ಸಿಂಗ್. ಹೌದು, ಎರೂರ್ ಸಾಹೇಬ್ರು ಇಲ್ಲೇ ಇದಾರ, ಅಲ್ಲಿದಾರ? ಇಲ್ಲೇ ಇದಾರೆ. ಲಾಸ್ಟ್ ಟೈಮ್ ಹಿಂಗೆ ಒಂದು ಸರಿ ಅವಾಜ್ ಬಿಟ್ರು. ಜಾಸ್ತಿ ಕಡಿಮೆ ಟೋಟಲ್ ಮೆಮೋಸ್ ಅಲ್ಲ ಅಂತ. ಏನ್ ಮಾಡಿದ್ರೆ ತುಂಬುತ್ತೆ, ಒಂದ್ 70-80 ಹಾಕ್ಸ್ಬಿಟ್ಟೆ. ಬರ್ಲಿ ಎಲ್ಲ ಅಂತ. ಆಮೇಲೆ ಏನಕ್ಕೆ ಇಷ್ಟೊಂದು ಸರ್ ಎಲ್ಲ ಟೋಟಲ್ ಮೆಮೋಸ್ ತಾವೇ ಹೇಳಿದ್ರು.
applicable to civil servants, your lordship. Currently, the officers that are trying to promote are not even categorized under the act. Therefore, the current CNR rules could not have even been enforced, your lordship.
Which rule you are saying now, which is violative of
Sir, A1.
uh,
A1 ಅಲ್ಲಿ produce ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ.
Annexure A1?
A1 ಅಲ್ಲಿ produce.
Order of case.
A is the order of case 80, your lordship.
A1 86. Chief Officer grade 1, Chief Officer grade 2. Method of recruitment 66.66 by promotion. 33.33 by direct recruitment. 3 years of service as Chief Officer, 2 years of probation. 3 years of service as Chief Officer grade 3. 2 years of probation. Student policy for Chief Officer grade 2, which initially required 1988 position of Chief Officer 3. State accordingly. Rule 3, the equivalent of Rule 5 of KM 1970, the method of recruitment adopted with KM as that. Chief Officer get 25% direct recruitment, 20% by promotion, 21% by selection of pocket revenue officers of the month. Agree. What is this? How these rules are
Mimic.
why they are violative of any problem?
That's just to begin with, the hierarchy has been seen by my lords. That's what happens is that my lords, prior to 2022, there are people who being appointed as senior health inspectors, revenue officers, office managers who used to do in the, for example, revenue officers would work in the revenue department, senior health inspectors would work in their respective departments. All of them, my lords, were being recruited by way of, for example, senior health inspector was recruited as junior health inspector by KPSC. They were at no point of time treated as government servants. Now, my lords, what happens is the petitioners before my lords, as of today, CO2 is Chief Officer grade 2 is a creation of a post by way of an examination, my lords, KMAS examination, Karnataka Municipal Administrative Municipal Services, by virtue of the Act, Municipalities Act. In other words, they would write an exam, get qualified, and from there, their circle would start, so far as the petitioners are concerned, whereby the next immediate promotion would be CO1. Now, what is happening here, and why we are before my lords, even before KAT, this was our submission, is that these SHI, senior health inspectors, revenue officers, and office managers, today by virtue of this particular new standard to be made applicable, are being directly given CO1 position, not even CO2. In essence, my junior officers, by virtue of this C&R regulations, have become, and now there's already another list being prepared to, to become my senior officers. That, my lords, would violate the Absorption Act.
the Prevention of Absorption Act of 2020, where it says, we had given a copy earlier, minutes. Now also we'll give you a copy. Last time I placed it on record. Yes.
Can I get-
This prohibits absorption. But how this act is applicable to your case? Where is the absorption?
Are not people pertaining to public service. They belong to, for example, let's say, corporation. They become public sector, and it's an undeniable position. In addition to it, even the Insurance Act, which is being applicable for the public service employees.
This speaks of absorption.
Yes.
Ban on absorption.
Yes.
Where is the case of absorption in your matter?
SHO officers who belong to public sector are being taken into CO2 position, which is a public service employment.
But it's not by way of absorption.
They're giving a legislation by saying that we are not absorbing, we are selecting. The selection was out of 10 people, 2 would be selected. Here is the case where all 10 get selected.
Yes. Why selection? Suppose there are about 100 vacancies and 50 people apply. All they meet the threshold bar. You mean to say all they cannot be appointed?
That's fine. Respectful submission. Just changing the example of saying 100 vacancies and 50 positions and 50 people can take the minutes, but not in a position where there are 150 people, 50 belong to CO1 and 100 belong to SHO. And whether they're taking the 100 posts, leaving apart the original public service employees. That's our argument in one line is what they do today is absorption and not selection. The reason we are saying that is methods, they can't be selected to CO2, which are a CO1 position, chief officer grade 1 position, which otherwise people would be entitled only by way of promotion. It's like giving a student double promotion, who's not entitled also.
But subject to correction, this ground appears to have not been taken before the tribunal.
Which the child. It didn't take up, we saw the liberty when the same objection was raised at the time admission with us. The laws also took the same ground and also gave us some time for the relief. But the reason why we are pressing, they are not going to file the objection today.
They need not file it. It's a constitutional validity. Not will, you are not, it appears you are not will.
Last night I had to rush to Tribunal.
Sure.
I came back.
We'll take this matter a week after next, tomorrow.
Now, the second batch of employees are now being promoted to CO2. Virtually, my juniors fellows are being now.
All promotions to be made shall be subject to outcome of repetition. So that you are protected now. All selection and appointment. Selection, appointment and promotion. Under the new C&R rules that are put in challenge shall be subject to outcome of the petition. Directed not to finalize the same. Not to entry matter idbittude. Innu better entry matter. All right. This is in all right. Ali further interim order and hakbeku. Heading further interim order. All right. Post in the second week of June 2025. Yes. Yeah, you have given now, the interim order is given now. There are many old matters. There are
Chances of promotion are affected and they can be affected.
that can be affected. If rules provide it, they can be.
There is no right to promotion, fundamental right, but only a fundamental right to be considered.
That's all.
And chances of promotions are subject to change.
This is not a case of absorption. But
But I
therefore you have
will
to
put the
bring,
counsel for the
literature.
petitioner on notice. Rajkumar's case covers this issue. Himachal Pradesh versus Rajkumar, my lord, decided in 2020. I'll give a copy to him so that we can assist the court on the next occasion.
Correct.
Full bench. 2023, volume 3, SCC 773.
Dispose ಆಗ್ಬಾರ್ದು. dispose ಆಗ್ಬಾರ್ದು. Photos just ಮಾಡಬೇಕು.